Lordship, I would like to mention item 16. We were supposed to file the newspaper publication. Lordship, we have got the newspaper. Today we will be filing the affidavit. So they did come on Friday or next week.
Item number
16, 16.
the request for the learned appellant matter stands adjourned for 3 weeks. 3 weeks.
Item number 1 to 14. Prohibition part heard.
Yellow কাগজ কিছুমান
One affidavit we have filed in WPC my lord 8220 of 2019. 8220 2019. Item 2, man. Item. That's an additional affidavit filed on 31/5. Another 2-3 paragraphs will be relevant. Three paragraphs. May I read those? Para 3, man. That by way of an additional affidavit, the deponent begs to submit that the government constituted a state-level empowered committee comprising the chief secretary to the government of Assam as chairman.
where you are reading
Page 1 to 8. 1 to 8.
filed by the activity in reply of the joint
No,
activity.
not reply. Man.
That is
The
the reply
additional
filed by
affidavit that we have filed. There is a reply to our additional affidavit.
When did you file?
On 31/5.
It is of 5th of June.
That affidavit, yes. Yes, this one.
Additional affidavit. Yes, tell me.
Para
Paragraph.
3 minus 1 to 8 to page 1 to 8. That by way of an additional affidavit, the deponent begs to submit that the government constituted a state-level empowered committee comprising of the chief secretary to the government of Assam as chairman, commissioner secretary finance department as members, commissioner secretary planning and development department Assam, and secretary personnel department as member secretary to optimize utilization of service of the government employees. The aforesaid state-level empowered committee was constituted by the office memorandum dated 6/12/1999. As per the said office memorandum, the commissioner and secretary and head of the department of the concerned department should attend the meeting of the state-level empowered committee as and when called for. Well, this is important, my lord. At the time of consideration of any proposal, the concerned, my lord, commissioner secretary will be called by the, my lord, SLEC and he will be present there. The said office memorandum further provided that the existing vacant posts, including those that might fall vacant in future, would not be filled up either by direct recruitment or by promotion without the approval of the state-level empowered committee. In our case, my lord, this is missing. The aforementioned office memorandum dated 6/12/1999 was circulated to all the principal secretaries, commissioner secretaries to the government of Assam of all departments by letter dated 7/12/1999, issued by the commissioner secretary to government of Assam finance department, and to all the deputy commissioners and subdivisional officers by WP message dated 22/12/1999. The selection and appointment of the writ petitioners in respect of the current writ petition in the district of Gwalpara, as well as the writ petitioners of WPC 1931 of 2020 in the district of Dibrugarh were made during the tenure of the state level empowered committee in February 2005 by the Joint Director of Health Services Gwalpara and the Joint Director of Health Services Dibrugarh. Now, my lord, para 4. That during the existence of the state level empowered committee, the government in the Health and Family Welfare A department by letter dated 11/4/2002 directed the Director of Health Services Assam and the Director of Health Services Family Welfare Assam not to issue any appointment orders until further orders, even in cases against which permission of state level empowered committee and approval of the Minister of Health Department Assam had been obtained, until further communication was issued in that regard. That
So
direction.
this is the ban.
This is the ban, madam. The said direction contained in the letter dated 11/4/2002 was further conveyed by the Director of Health Services Assam to all the joint directors of the district, additional directors of Health Department, etc. by letter dated 22/5/2002. From the aforementioned letter dated 11/4/2002, it is apparent that the Director of Health Services Assam is the appointing authority for the grade 3 and grade 4 staff in the state under the Health and Family Welfare Government of Assam. Again, from the letter dated 22/5/2002.
No, wait. From the aforesaid letter dated month, it is apparent that the Director of Health Service is the appointing authority.
No. The next para, Lord, kindly see. Again, from the letter dated 22/5/2002, it is apparent that the Director of Health Services at any point of time had the authority to delegate the power of appointment of grade 3 and grade 4 staff to the Joint Director of Health Services working under his establishment in the different districts. The Director thereafter my lord communicated to the Joint Director stating that he cannot give any appointment during this
Understood. But this happened in the month of February 2005.
2002.
No, the appointment.
Yes. Thereafter, my lord, may I proceed?
No, appointment
Yes,
happened when?
February 2005.
5, na?
Yes.
Okay, then.
Para 5.
So the power of delegation was there by the communication dated 22/5
My lord.
that the joint director can do.
Yes. No, not my lord. He has the authority to give the
So therefore, the
delegate the authority.
power of delegation has been given to the director by the communication dated 22/5.
No, he has the authority to give the delegation, my lord. He can delegate the power, but it will have to be.
Therefore, Mr. Gogoi, this court is not saying
Yes.
that the joint director was given the power.
Yes, yes,
No,
that
but
authority
the
he has.
power to give the delegation is there on 22/5.
Yes.
Then
There was no service rules pertaining to appointment of grade 3 and grade 4 staff under the Health and Family Welfare Department, Government of Assam, and as such, the Assam Public Direct Recruitment to Class 3 and Class 4 Rules 1997 was followed for selection and appointment in the grade 3 and grade 4 posts of the district. The Rule 3 of the state rule prescribed that the aforementioned rules of 1997 would apply to only those Class 3 and Class 4 posts where there are no service rules, executive orders regulating the condition of service, and which are not within the purview of the Commission. The Rule 2A of the state rule 1997 defines appointing authority as the authority to whom the power of appointment is delegated. The Rule 4 prescribes the provision for the direct recruitment, and Rule 5 prescribes the provision of constitution of selection committee of Class 3 and Class 4 posts in different offices of the state, for which there was no service rules in existence. The sub-rule 3 of Rule 5 prescribes that the administrative department shall issue instructions regarding the minimum essential qualification for direct recruitment to the post or posts, the age limit of candidate, the minimum essential experience, if any, for the post or post, whether there will be written test, and if so, the name of the papers and the maximum marks for each paper, whether there will be any typing test, and if so, the minimum marks of typing test, and whether there will be interview, and if so, the minimum marks of the interview. In the present case, there was only interview. Case of the petition as well. From verification of the records of the selection and appointment of the writ petitioners of WPC 8220/2009 relating to Gwalpara and WPC number 1931 of 2020 relating to Dibrugarh district, as well as verification of records of the directorate, it transpires that prior to initiation of the selection process, the then Joint Director of Health Services of of the two districts did not seek for any approval of state level empowered committee as mandated in the OM dated 6/12/1999. This is my lord relevant. The opponent begs to submit that the Joint Director of Health Services, in order to seek SLAC approval, would have to move the proposal to the Director of Health Services and the government in the Health and Family Welfare Department. But there is no such records available in the Directorate that the then Joint Directors of Gwalpara and Dibrugarh sought for SLAC approval prior to conducting the selection. Further, though the appointment of the writ petitioners of WPC 8220/2019 and WPC 1931 of 2020 have been issued by the then Director of Health Services, Joint Director of Health Services Gwalpara and Dibrugarh. However, no such power for appointment was delegated by the Director of Health Services Assam to the state two Joint Directors of Health Services for issuing the appointment letters in terms of Rule 2A of the Rules of 1997. That apart, there is no records available in the Directorate to show that any instruction as regards the
If we
essential.
just pause here,
My lord.
did you give any delegation to the Joint Director of Health Service at a later point of time?
No.
So
Nothing
as
is
of
there in the
now,
record.
from then till now, the Joint Director of
No,
Health Service
no.
was never
Otherwise, we, have,
appointed.
my lord, we would have mentioned it in the affidavit. No point of hiding that. We have checked, my lord, there is nothing, my lord, no communication from the
So
Joint
at
Director.
no point of time, the Joint Director of Health Service was given the appointment or
At least for no, at least for this particular selection.
no, now also. When did you start?
But now, my lord, after my lord 2005, in 2006, my lord, later also will find it is the director who is the appointing authority now because of all these anomalies and all it have been detected.
So if it is the director now in 2005, why are you saying that it is now the director, not earlier? Was it the Joint Director?
No, it delegation, my lord, delegated.
So was
Is the
there any
rule prescribed,
delegation prior there too?
my lord?
Was there any delegation at any point of time to the Joint Director of Health Service?
That part, my lord, for this
That
query
is
has not
the
been
most pertinent question because you are saying that he was never.
He has never delegated.
So
At least for this selection, well, that's why we have indicated Gwalpara and Dibrugarh.
no. Do you delegate only for the purpose of a particular selection,
Yes, ma'am.
or do you delegate as a whole?
Not as a whole, my lord. For a particular selection, if they approach, then, my lord, it is given, my lord. They will have to, first of all, my lord, for SLEC, they will have to move through the director. And
We'll come
accordingly,
to that SLC later on, but first on this point, as regards the Joint Director was never given the.
for this
Authority.
particular selection, at least.
So therefore, earlier to that you used to give.
Yes, ma'am. That part, my lord, of course, there are appointments being made, my lord, by the joint directors of various. It's not that, my lord.
How are you giving it?
My lord, that.
Do you say that okay for only for this particular selection we are giving
No,
him?
the delegation is not in general, my lord, to my knowledge. Not in general that by way of notification it has been given to the joint director for of all the, my lord, districts of the state.
But but Rule 2A does not mention, as per the rules of 97, that that delegation has to be selection specific.
Yes.
It does not.
It does not.
Then
That apart, there is no records available in the directorate to show that any instruction as regards the essential qualifications, age limit of candidate, minimum essential experience, mode of selection was prescribed by the then Director of Health Services to the concerned Joint Director of Health Services as prescribed in the sub-rule 3 of Rule 5 of the Rules of 1997. Thus, the selection and appointment of the petitioners of WPC so were made by the respective Joint Directors of Health Services without any authority and in blatant violation of the relevant provision of the Rules of 1997, as well as the executive instructions prescribed in OM dated 6/12/1999 and 7/12/1999. And as such, the state appointments are illegal and not sustainable in the law and liable to be terminated, which has been done in the case of the writ petitioners of the above mentioned writ. Para 6, my lord. The deponent begs to submit that the government in the Health and Family Welfare Department imposed a total ban on all kind of appointments until further orders, even in cases against which permission of state-level empowered committee and approval of the Minister of Health Services, Health and Family Welfare Department was there until further orders, and accordingly the state direction regarding ban on appointment was duly intimated to all the Joint Directors of Health Services of State, quite later dated 22/5/2002 by the Director of Health Services Assam. The aforesaid ban continued in the Health Department till the dissolution of the state level committee, while OM dated 4/7/2005 issued by the Finance Budget Department. Assam, and the staff inspection unit was delegated with the responsibility to look into rationalization of recruitment of staff in various state government offices. Subsequent to the ban imposed by the government of Assam, Health and Family Welfare, by letter dated 11/4/2002, and resolution of the state level empowered committee by OM dated 4/7/2005, for the first time, selection and appointment of 76 numbers of posts of grade 3 and grade 4 under the Health and Family Welfare Department was conducted in October 2006.
Now,
Well, here I
just
pose,
so
my lord,
if we
after the
pose-
ban imposed in
no,
2002.
okay. Now tell me, till the dissolution of the state level empowered committee,
There was no selection as per the record of the Director of Health Services. No select, not a single selection.
and 4/7/2005 is relevant because the SIU comes.
SIU came in. Only thereafter, my lord, for the first time, the safe drive.
4/7/2005 is also AFRBM.
Yes, yes.
That's the date.
Yes, sir. The safe drive was initiated pursuant to the letter of the Health and Family Welfare Department, Government of Assam, issued by numbers 19/1/2006, and as per approval of the Finance SIU Department dated 3/8/2006, mentioned in the letter dated 8/10/2006, issued by the Finance Budget Department. Thus, from the aforesaid fact, it can be stated that the ban which was imposed in 11/4/2002 continued till 2006, that is, post dissolution of the state level empowered committee, and it was lifted only in January 2006. Hence, the appointment of petitioners were made by the concerned Joint Director of Health Services, Gwalpara and Dibrugarh, within the ban period without authority, and thus same are vitiated by illegality. The Lordship will see this, my lord. Others documents Lordship has already perused. These two documents, my lord, the last document at page 1306. The post ban period, my lord. 1306, it is the letter dated 19/1/2006, issued by the Undersecretary, Government of Assam, Health and Family Welfare Department,
Where?
at page 1306 of the affidavit, madam, Annexure G. I am directed to say that Cabinet in its meeting held on 7/3/2005 decided to launch special recruitment drive for filling up the backlog vacancies. Because of this, my lord, ban, my lord, there was backlog for SC, STs and physically handicapped persons. Accordingly, you are instructed to take all necessary steps in this regard for filling up of such vacancies. The matter has been badly delayed. You are therefore requested to fill up the vacancies as decided by the Cabinet urgently and issue appointment letters to the deserving candidates against the selection made through selection committee without further delay, under intimation to the government and the subcommittees of welfare of SC and ST Assam Legislative Assembly. DSSFW Assam shall take similar steps in this regard. This has the reference to the discussion held on 19/1/2006 in the chamber of the Honorable Minister, Health and Family Welfare, to review the progress made on the matter, along with other issues relating to the Health and Family Welfare Department. Now, in the next page, my lord, page 1309. This is the letter of the Finance Budget Department, my lord, intimating the Treasury officers regarding the, my lord, election and appointment of 76 numbers of posts under Health and Family Welfare Department. And, my lord, the approval number is given. My lord, after the SIU came into being, my lord, additionally, one condition was imposed that, my lord, not only the SIU approval number will have to be intimated to the Treasury so that he can release the salary only after getting that number. Additionally, the budget, my lord, department, Finance Budget Department will also intimate the Treasury. Only thereafter, my lord, any department after making the recruitment, the concerned newly appointed employees will get the salary. So here, my lord, this was intimated. And it appears, my lord, the Budget Department's SIU approval is also there. That number is, my lord, FSI 2/2006, dated 3/8/2006.
Now tell me whether these petitioners were appointed in 2005.
Apparently, my lord, from their own record furnished by the
February
additional affidavit.
2005.
Yes. Just prior to, my lord, the resolution of the SLA.
What was the resolution?
No, resolution of the SLA.
Okay. So they were, whether did they get their salaries then immediately thereafter?
My lord, according to their statement, my lord, they are getting it, my lord. In fact, they have given the attendance register also, stating that they have been working. So It is there on record.
Attendance register, we are not
No, no,
concerned.
there is the acquaintance rule.
That is a question
Acquaintance
of
rule, yes,
fact.
acquaintance
But
rule.
rule.
the question is, without the SIU's approval, who is required to take as
Yes.
per that notification?
No, my lord, it was prior to my lord SLEC, SIU. Before dissolution of my lord SLEC, this was me. All these conditions came into being, my lord, only after the finance SIU department was entrusted with the responsibilities of SLEC. So every appointment, my lord, thereafter was required to be, my lord,
So you mean to say that the executive instruction
my lord,
which was issued
my
as lord, regards the formation of the SIU
Lord.
was prior to, was for the purpose of bringing, of applying the rules
my lord.
of 97.
Almost the same, my lord. In fact, it has become more strict, my lord, now after the SLEC. Because, my lord, it has been very categorically provided to all the departments that you cannot, my lord, make any appointment without the prior approval of the SIU. Before conducting the selection, my lord, process, they will have to seek the SIU approval. Thereafter, they can
Now too it
proceed.
is okay.
Yes.
But at that point of time,
In fact, my lord, at that point of time, to the SLEC was there, but because of this ban and all, probably because of the anomalies that were detected, that's why the ban was imposed in 2002. Here, my lord, the joint director, just before the resolution,
but does the
it is-
rule 1997 is overridden by the
my lord, this, my lord, so far as the procedure of conducting the selection is concerned, that is prescribed in 997. But this is an additional criteria given to the, not for selection, prior to selection. SIU or SLEC is prior to selection. Selection will be held pursuant to a particular rules or executive instruction or some order, madam.
So you mean to say before,
Before
starting
selection,
the procedure,
SIU
they
or
have to
SLEC
take
is
the
required.
permission from the SLEC.
My lord.
Let us read that particular document.
My lord, that lordship will find the constitution of the SLEC
1293.
1293.
Where is it mentioned that without the SLEC permission you
My
cannot
lordship,
be-
that, my lord, first of all, lordship will see, my lord, after the constitution of the SLEC, my lord, that committee, immediately the paragraph, commissioner, secretary, and head of the department.
1294.
So and so.
1294.
No, it is there, my lord, the bold part, we have given it. The existing vacant posts, including those which may fall vacant in future, will not be filled up either by the direct recruitment or by promotion without approval of the state level empowered committee.
So this is an executive instruction.
Instruction. This is prior to conducting the selection. Selection will be as per the rule.
So it has to be now. There was no SLEC permission.
Not. It was not mooted to the director, and there is no SLEC. They cannot directly submit any proposal to the SLEC without mooting the proposal through the director. And from our record, we have stated in affidavit, there is no such proposal forwarded by the joint director of Gwalpara and Dibrugarh for conducting that particular selection, which is the subject matter of the present dispute. Dibrugarh and Gwalpara.
So overall,
My lord.
let us forget about the
Lordship.
other case. These two cases were the Trump cases. Your thing is that there was a formation of an SLEC. As per the notification, which is an executive instruction under 162, for applying the rules or taking any step for the purpose of going ahead with the selection procedure, the authorities have to put it to the SLEC.
Lord.
And without the approval of the SLEC, nothing could be done.
Nothing can be done.
So your first and foremost submission would be that there is no SLEC approval which have been taken.
Lord.
The second would be, even assuming there was a permission, there was a ban
There was a pair. Yes. There is a second.
for which
Now-
the appointment could be done.
Final.
Even assuming that there is a ban, no permission of the SLEC, the ban was lifted and all this.
My lord.
The joint director of health service was never authorized.
Yes.
So he could not have exercised the powers in the appointing authority under the like.
Fine.
So that is your law.
Yes. And my lord, lastly, as per sub-rule 3 of rule 5, whatever is the criteria for selection, that will have to be prescribed by the director at the administrative department. Here it will be the either director or the government in the health department.
No, why do you require it with the rule to specify?
So that's why I'm saying, my lord. That also, my lord, the joint director never moved the director or the government for prescribing the criteria for holding the selection for this state purpose.
So,
That is the
but
last one.
your termination of the
Doctor.
was based upon the ground of that there was during the ban period.
Yes, in the selection scrutiny committee report, it appears, my lord, that is the one of the main prime ground.
What is the other ground?
Other, my lord, SIU approval was not there. Whereas,
SIU
my lord,
was not there.
because at that time SIU was not there. Yes,
So that couldn't happen.
though they have mentioned it in the remarks column.
So only thing is ban.
Ban.
Not the other.
Others, my lord, apparently,
not
my lord,
related to the.
in fact, my lord,
Now
these,
can by way of an affidavit to improve that.
of course not, but moment we place this particular, my lord, facts before this honorable court under 226, my lord, petition, that too before a court of equity. Of course, my lord, honorable court definitely will question the petitioner as to their bona fideness of the appointment and all. And it is apparent, my lord, that there is no such record from our part, as per the rules, my lord, which the joint director ought to have, my lord, taken the SLSC approval, the delegation of his power for his appointment. Thereafter, my lord, as per sub-rule 3 of rule 5, that, my lord, criteria, whatever, even if he proposes, the joint director approves it or director approves it, that would have been good enough. But nothing is there on record.
But is there any document to show that the ban was lifted?
My lord, that's why, my lord,
Except
we have
what you have
pointed out is
stated in
only in January 2006, because the ban was imposed by as per the direction of the government. We have only communicated it. The director has communicated it. In 2006, the government itself directed the director to immediately fill up all those vacancies.
But
And-
prior to that, on 7/3/2005, the
My lord.
cabinet said that there is a long overdue,
Fine.
and as such, we need to go. Wouldn't that be a cabinet decision saying that the ban is lifted?
That cabinet, perhaps, my lord, this point was not discussed because it is
No,
not
but
reflected.
why did the you move it out or have taken the action under 18/1/2006
Man,
on the basis of a cabinet decision?
that cabinet memorandum, of course, not
It is
reported.
there from your letter itself.
It is mentioned, yes.
So on 7/3/2005 itself,
There was a
government
move.
as a cabinet
My lord.
have already taken the decision.
But, my lord, appointments were made in that case also, my lord. The appointments were made in February itself.
It's a different thing.
Yes.
The effect was given at the latest time. So to say that there was a ban at that point of time, would it be proper when the cabinet has taken the decision that no further
The
ban?
cabinet was in, my lord, March 2005. The appointments were made in, my lord, February. By February, it was over. They were given appointment within a period of 1 month, my lord, and the election is over. And in case of, my lord, most probably Dibrugarh, though post was in Kualpara, my lord, 70 posts were advertised, 78 were appointed. It's not that, my lord, some were appointed later. From the, my lord, appointment letter, it appears, my lord, all were appointed.
But that is not a ground.
They
on
again
which
an
you-
excess appointment, of
But
course. my
those
lord.
are not your grounds. for
But that, my lord, we have come to know, my lord, of all these facts came up only when the writ petitioner of these two districts to writ petition, they filed one additional affidavit by bringing all these records before this honorable court.
Because what happens, the problem which this court is finding is,
Yes, madam.
on one hand, the director of health service says that we don't know anything.
Yes.
On the other hand, your office, who is under your subordinate, the joint director keeps on issuing documents. Yes, there was selection. Everything. So your own directorate, it's still, at that point of time, it's okay, still not speaking in the same voice.
Yes, my lord. Because, my lord, it is
No,
not there in a record.
No,
And
no, as of
subsequently,
now also,
my lord, even if, my lord, the selection was held in say 2000, February 2005. Subsequently, my lord, if there is some irregularity, say for a, my lord, sake of argument, I am saying, my lord, that there is some irregularity in the selection. During this period, my lord, there is not an initiative from the joint director to move the director to regularize that period. Say, my lord, ex post facto approval of was subsequently sought from the finance SIU or SLEC, whatever it is. That delegation power, supposing that was condoned.
Mr. Guga, you are digressing. I'm saying, as of now also, from the
Yes.
RTI application,
My lord.
the joint director is clear and unequivocal. Yes, we had everything. We have done everything. Even for the fact that there was a proper selection being carried out by us, as well as also, but the officer doesn't remain the same. Because
That's
that
why
director
I
who
would
has
have
done
pointed
it.
out, my lord. The then director has conducted this. So, present
Possibly, but-
joint director only will speak, my lord, whatever is available in his record. And accordingly, these records were there. Accordingly, it was furnished to the writ petitioners when the RTI application was submitted.
He also goes to the extent of saying that the joint directorate office was never informed about the ban of 11/4/2002.
My lord, that communication, in fact, it was duly
Isn't that-
circulated.
Yeah, if
Page-
that be so, isn't your whole department is not acting on the same thing?
My lord, page 1302, that by this letter, the ban, the direction for ban, my lord, was duly, my lord, circulated to all the joint directors.
Please find herewith the government's letter dated so and so and to request you not to issue. So
Well-
this letter was never received as per what they have produced by the RTI, isn't it?
That part.
That RTI, he has produced something on the RTI. Na? Okay. We need something. Yeah.
My lord, one document 1269 of that additional affidavit, 1269. This is a RTI reply to Narayan Prasad Rava, who is the petitioner of Walpara's case. Lordship will see the answer. At present, the required documents like acquaintance roll, salary statement of grade 4 employees with effect from July 2008 to 2014 is not traced out by this office till date, as most of the documents are missing due to office shifting and destroyed by termite during storage. Well, that particular statement that, my lord, this ban instruction for ban, my lord, that was not, the joint director was not in knowledge of that particular document, my lord. I have not come across.
This is in reference to the RTI dated 6/5/2022. Now kindly 6/5/2000 and page 1265.
1, 2. Well,
Number, what are the questions asked? Since when the authority power regarding the appointment of grade 4 employee by the Joint Director of Health Service has been curtailed? When and what date such an order have been received by the Joint Director from the Office of the Director of Health Service? Then you see the reply. at page 1267. I am to inform you that the information as sought for by you as per the RTI application dated is not received by this office. Then prior to that again you see, huh?
1 to
Kindly see.
Well,
1262. Government notification regarding SIU. Details of information as seen. When did the SIU for grade 4 employees have come into effect? Is there any order with respect to the SIU for the grade 4 employees received by the office of the Joint Director of Health Service, Gwalpara? Please supply a copy. Answer here is
160, 64.
I am to inform you that the information as sought by you is not received by the office.
well. The SIU is not the issue here in matter because they were appointed prior to SIU. And by this statement that this office, this information as sought for is not received by this office, whether the joint director wants to mean that there communication was not made to him, or it is not available in the record.
You are the best one to say. You are representing them also.
My lord. But apparently, from our record, but why I'm saying is,
That
even
is
for
why I am
SLAC,
saying. I understand.
my lord,
You being the finance, he being by the panchayat have always a fight amongst you. For that it is okay. But when your directorate being the same, a director of health service,
Joint.
joint director, speaks in different voices, what do you do?
here, apparently, no such proposal was made.
And if we have failed to streamline from 2002 onward,
Right.
then it is really a sad state of affairs. Yes, what do you say?
My lord, the first point, my lord, which I would like to clarify. My lord, the health department, as the time goes, they are changing their mind. They are changing their. First, in the affidavit, they said the 93 ministerial rules. They were sticking to that. So they said the appointing authority is not the joint director, it's the director. Then they file an additional affidavit and bring on record, my lord, certain facts, which, my lord, I'll just like to, my lord, show as to how it cannot be, my lord. It is by 131.
So as per you, what rules should we follow?
My lord, they have their own instructions, aptitude instructions, they are following that, and the process that is there.
Where is
From-
that?
In 99, my lord, the appointments are made by the joint director. By
Where is
giving-
that instruction?
my lord, that's the process there. We don't know how.
No, how are you saying that?
Because, my lord, in 98, 99 also, appointments were made by the joint director.
You can't go on that. When
Anyway, my lord-
unless
my
you
lord-
show me there is an
My lord,
because they say that in view of that there
Fine.
is no executive instructions and as such
the
rules of
97 rules will follow. And the further submission of my friend is that to establish that the 97 rules were not followed, he said that the administrative department had not given any criteria or the guidelines as to how to hold this election. That is one of his primary contentions. Now, my lord could see in 2005, the cabinet takes a decision that there has to be a selection, backlog vacancies. Backlog vacancies will arise if there were recruitments being made. If there were no recruitments being made, there will be no backlog vacancies. So it presupposes that there were recruitments being made, but the SC/ST quota was not being picked up. So in 2005, the cabinet takes a decision, fill up the. Now, you say 1997 rules. So what were the instructions given by the director or by the government to the joint director to conduct that selection?
They say the director was never informed.
No, my lord. 2006, that latest one, 2006, they'll have to stand, my lord. If that is their consistent stand, that it's the 97 rules that we follow and this is the method we follow. So in 2006, that selection that was held, they have given those directions. Why have they not placed that before you? That's being kept away. That there is no whisper on that. So they say one thing, but they don't go ahead. I'll satisfy your lordship. Now, with regard to that appointing authority and the ban, My lord, if lordship comes to the additional affidavit. Ah. If my lord comes to page 1302, my lord, that ban letter, that itself shows, my lord. The letter is at page 1303. Starts at 1302. Letter is at 1303. My lord, may permit me to read. Please find herewith the government letter number so and so, and to request you to not to issue any kind of appointment order until further orders, even in cases against which permission of SLC and approval of Honorable Minister so and so has been obtained until further communication from government. Now, my lord, if the director was the appointing authority at that point of time, there was no requirement for him to issue this letter, my lord. It is issued to all the joint directors. So that itself shows that the director was not the appointing authority. The appointing authority was the joint director. Now, my lord, we are in a situation in 2023, but we are not in hand except those documents which we could bring by way of RTI, which we have already placed before your lordship. There is the advertisement, there is the select list, there is, my lord, the acquaintance rules, not the attendance rates, sir. The acquaintance rules. Acquaintance rules are those, my lord, wherein the payments are. Because at that point of time, it was not the, my lord, account. It was, my lord, by way of cash being paid to us. Now, my lord would see what had happened in this. If there was no SLC approval, that was a transition phase. My lord, let's give them the benefit of doubt. That during the transition phase, something had happened. So that maybe could not have been detected at that point. Let's for a minute, my lord, assume. Now, my lord, there is another factor which the FRBM Act came into. And under the FRBM Act, in this state, it was the, my lord, the finance who was doing it, finance, my lord, department, SIU department. They went to each of establishment, examine the strength and everything, my lord, the posts which are there, posts which are not there, when it was filled up, how it was filled up. Then they made a list for all over the state. Now, for the district establishment, the committee was constituted with the deputy commissioner as the head. Now, why this was constituted, my lord? Because there were posts which were there, which they said were not needed. So these posts were to be abolished. Because at that point of time, my lord, the salary budget was very high. They wanted to bring it between, I think, my lord, 30 or 40% of the whole thing. So under that exercise, they carried out a rationalization examination. They went to each and every, my lord, because that ought to have been done. They went to each and every establishment, took the documents, saw the posts which are there. From 2001, if a post is vacant, then they took a decision whether that post should be declared as redundant, abolished, or it should be continued. It is thereafter, my lord, after this whole exercise was done, that, my lord, sometime, my lord, it took, I think, went till around 2008, 9, 10. Thereafter, my lord, the OM, the effect of that approvals and all were relaxed. Now, my lord, the finance, treasury will never clear up this. If either the SLC number is not there and this clearance from the SIU is not there, I give up that also. Now, my lord will propose allow me to make one submission. My friend will not dispute with that. My lord, the budget of the particular directorates and the officers, district officers under it, is made by the director. And then it's sent to the administrative department forwards it to the finance budget. That's the way it goes. Now, till 2005, our appointments were made. These posts did not figure within the budget. At that point of time, my lord, there was a flux because of the Assam Good Governance Project and all those things. FRBM Act came into being. Thereafter, my lord, the budgets were being prepared. Now, these posts came in. So, these posts, there is an increase there, my lord, in the budget. The directorate approved it. The finance cleared it. And the treasury was paying. Today, without, my lord, bringing on record any other thing, just bringing a document on record, without showing the effect of that, well, these submissions cannot be advanced. Now, even if I say,
Mr. Nair, the moment I take that submission.
Lordship.
Wouldn't that apply to all other cases?
All other cases, my lord, there is a difference. I would like to place. In the other cases, my friend will show, my lord, the salaries were paid sometime in 11 months, 11, 12 on.
That is the direct
Regularization order?
Oh, they were casual employees, my lord, they were regularized. That
Oh,
order,
that by that person.
that for Hossain. It was paid in 2011. But here, my lord, they can't dispute this. Those payments were made from the month subsequent to the hour appointment.
So
And-
this is only in respect to this Dibrugarh and
The
Gwalior.
Dibrugarh and Gwalior, not the others. Others, it's a mercy petition, if I may say. Now, my lord, today you say many things.
Now tell me, if the authority, if there is an absolutely illegal effort or illegal appointment being made, but during this period, if the authority, just for the example, the director of health service, finance, everybody are in a conspiracy.
Gotcha. I got it.
For which there was nothing being pointed out also that these things have happened. Would that legalize the appointment?
Will not. Will not. But, my lord, there will have to be materials brought before my lord by them to show this nexus. There is nothing, because my lord will notice one thing, my lord, that the director, joint director, finance, treasury, these are institutions wherein the incumbents change every 2 or 3 years.
Where is the FIR?
Well-
FIR file.
FIR was filed by the date I cannot say, my lord, but it was filed. And in fact, the hidden joint director was a, my lord, accused in the FIR.
What is the reason why you have accused him?
Well, not only this, my lord, the entire this scrutiny process for various grade 3, grade 4 and all, my lord. Not
So
only,
why
my
have
lord,
you done that?
because when these anomalies were pointed out, and my lord, in some cases, Lordship will find that, my lord, the signature, my lord, the appointment letters were issued with the signature of the
When
director.
did you come to know about this thing?
My lord, in fact, that started with the episode of Jorhat, my lord. Some public complaint was, my lord, lodged before the CM Vigilance Cell. CM Vigilance Cell directed, my lord, to the
Which year?
sometime, my lord, that, of course, my lord, there litigation to that effect. That year I cannot.
Yes,
directly-
any idea which year?
My lord, I think it's prior to 18 or round
Yes.
about 18. And it was with regard to, my lord, surveillance purpose. It was with regard to surveillance purpose.
No, not only
Appointment
surveillance.
at all.
All grade 3, grade 4 and surveillance workers all were, my
No,
lord.
no.
put in
First surveillance workers, and thereafter, my lord, they said, examine the grade 3 and grade
Yes.
4.
So by the time the director had retired,
Yes,
Many
retired.
directors had got. 2, 3, my lord, we
Yes,
have.
2, 3 by now has already retired.
but how many directors have you impeached?
So he, at that point of time, my lord, only the Dhruva Hosai was accused. He was there for a long time, my lord, and during his tenure, it is.
And what about the other directors who were paying giving the budget proposal?
But budget proposal, it comes from the government, my lord. It is whatever is the requirement. Always, my lord, it comes from the proposal. It initially comes from the district. Then the director used to forward it to the government. Government used to forward it to the finance department. And
So
accordingly,
whenever you
it is
prepare a
sanctioned,
budget,
my lord.
the-
Because, my lord, these posts
the
are otherwise
district-
sanction posts. These are
the-
not, my lord, some, my lord, excess appointment has been made without any sanction post, some is working. These are sanction posts. That's why probably, my lord, the budget were placed and accordingly it was released. And they were getting salary, the present petitioner. They were appointments were made in sanction post. But the prescribed procedure for filling up those vacant posts of, my lord, vacant sanction posts, that has not been followed. That's our case. No doubt, my lord, that nowhere we have stated, my lord, that they have been appointed in some non-sanction post. They were appointed in sanction post, but the procedure prescribed in the rules as well as various executive instructions like the SLC notification.
then how did in the other batch, those were casual appointments being made
My lord.
against sanctioned posts.
No, casual appointments in my lord, so far as Siftagar is concerned. My lord, only all these things came up only when my lord the scrutiny was conducted for all the my lord grade 3 and grade 4 appointments or persons who are working in the health department. At one go, the entire my lord scrutiny was made, and all these things my lord popped up only at that point of time.
So your
It
therefore
was beyond
submission
the yes,
is
not within the knowledge of the director.
as it was in vacant posts, these appointments were made.
But so far as Gwalpara and Dibrugarh, I am saying that, not about Sagar.
for Gwalpara and
Regularization, my lord,
Dibrugarh.
without the policy of the government, my lord, the joint director, he cannot, my lord, give any regulation of it. Or the
No,
director.
that
even.
too, no
Yes.
problem.
That is
There
for
we have no
Siftagar.
problem. But only as regards this. Hello, let me hear him.
My lord. Now, my lord, I can only show before today, my lord, before my lord, is the effective.
Hmm?
Because what would have been if it was an illegal appointment? What would have been the situation at that point of time? It was something which would have come up in 2005 itself. Because in 2005, under the my lord, when they created that SIU, if my lord can have the my lord that additional reply 1017, where my lord had read the RTI replies. Affidavit in reply, my lord will come to 127.
1, 2.
71.
Yes.
On expiry of the term, this is my lord for note of 07/2005. On expiry of the term of the state level empowered committee on 3/6/2005 and pursuant to enactment of the Assam Finance Fiscal Responsibility Budget Management Act 2005, it came in May 2005. The Governor of Assam is pleased to dissolve the state level empowered committee, which was constituted by so on 6/12/99. From now onwards, Finance Staff Inspection Unit Department will look into rationalization of requirement of staff in various state government offices. The SIU will undertake the following task. It shall look after the rationalization of existing government staff with the assistance of the district level committees, which may be constituted as follows. Deputy Commissioner, ADC, SDOC, district level officer, department. The state district level committee shall identify the redundant posts in the district in different departments from time to time and submit report to SIU branch in the finance to enable the state government to redeploy them rationally on demand from the requesting department. Then, my lord, the 2 and 3 are, my lord, with regard to new posts. Then it's with regard to new posts. Then, my lord, would come to page 1272.
7.
2. Next page.
72 is the same page.
Sorry,
No,
my lord.
oh,
1272. My lord. My lord is in 172, 1271. My lord will have 1272.
Okay. Oh, yes. This is a letter, but this letter is the 14th
Date, my
of
lord,
July.
14th. Then, my lord, dissolution so and so. All the admins are requested to advise all DDOs under the administrator to indicate the reference number of the so and so while submitting the treasury salary bills of employees who were are appointed and joined after so and so. Failing with the treasury officer will not entertain the claim. However, employees appointed with the approval of the SLEC or appointed in compliance of the court order before the date mentioned above, appropriate appraisal number respectively of the SLEC is to be indicated in the salary bills. Now, my lord, without this, they cannot release. Then, my lord, will have 3. Finance Budget Department will issue a list of new appointees of so and so to the enable him to pass and necessary in so and so. Instructed not to pass salary bill of new appointee without clearance. My lord may ignore that. Now, my lord will come to 1274.
7.
4. My lord will have the second paragraph. It is hereby clarified that the function is to examine whether an existing sanction post which had fallen vacant has outlived its utility or is essential to retain and fill up the post in public. This will include proposals for appointment and compassionate ground also. Similarly, in cases of proposals of creation of new post or upgradation of existing post, the role of so and so is to examine whether the proposed creation or upgradation is essential in public. Finance SIU will advise the concerned finance expenditure control branch accordingly. Now, madam. Further, another basic function of the Finance SIU department is to look into the rationalization of deployment of existing staff in various state government offices. So far as the government departments in the secretariat and offices of the heads of department are concerned, Finance SIU will initiate the exercise of rationalization at his own motion. That was I was submitting, Malam. In respect of rationalization of deployment of staff in the district level offices, Finance SIU will be assisted by the district level committee as laid down in para 1 of the Finance Department OM dated 4/7/2005, which my lord has already seen. It is clarified that there was a standing instruction from the Finance Department to all treasury officers not to pass any salary bill of a new appointee without reference number of the state level empowered committee. This became necessary in view of the fact that appointments were made in excess of the number of sanctioned vacant posts in some departments. The SLC has been dissolved by the OM dated so and so. After dissolution of the SLC, the treasury officer have been advised not to pass salary bills of any new appointee without reference to the Finance SIU department for filling up the post. It is further impressed upon all that no post, whether existing or new, should be filled up without clearance of so and so that the new appointee doesn't face. In this connection, para 3 of the Finance Budget Department letter is
Are you saying that the petitioner were getting the salary on the basis of the SLC's number?
because my lord, it had everything at that point. If that was the norm procedure that was followed, you will have to, otherwise the finance will not give me my salary. And my lord will also have the last paragraph. It's with regard to new appointees. But my lord, that was the requirement in 2005. And from 2005 till 2018, never was a question raised. Regularly being paid, just like a nominal, which I was. And my lord will now come to 1276.
1, 2, 7, 5.
From 2005, these exercises were going on. In 2012, my lord, my lord will have the second paragraph. Since considerable rationalization of scam has been achieved in the process during the year 2006 to 2010, due to successful application of the laid down workflow staff yardstick modified in the current context, etc., the matter was reviewed and the government has now decided to relax the provision of the OM cited above by entrusting the responsibility of issuing prior approvals for filling up of the required so-and-so existing vacant of different so-and-so excluding so-and-so, 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 so-and-so to the senior most secretary of the department. Such approval shall be issued for a financial year on conditions noted in paragraph 3, so-and-so, in a planned and consolidated matter and not in an ad hoc manner with intimation to the finance budget department. Why I'm showing this to my lord is that this exercise of identifying each and every post they have done was gone into. And once my
And
lord,
also they didn't find
they
anything.
didn't find anything because there was nothing to find out, my lord. There was a select list, there was an appointment, there was everything. Salaries were being regularly paid, budgets were being prepared. In 2012, they relaxed that. Once, my lord, that exercise was complete. Anything was there, my lord, it would have come up.
Finally come to paragraph 3.
3. The senior most secretary of the concerned head of the department shall issue approvals, prior approvals for filling up of duly created and retained vacant sanctioned posts for a financial in consolidated orders as stated above under his or her signature, clearly indicating the original creation number and last creation retention number of the post with intimation to the Finance SIU department after due examination, diligence and on the following conditions. Only existing grade sanctioned grade 1, grade 2 and grade 3 posts except all posts of teachers of elementary schools and drivers that are essential for public purposes shall be so approved for filling up and being filled up. This is the process after 2012.
Number 2.
Lordship,
Now, why I'm asking is because that regularization which was there,
Lordship.
finally come to number 2.
3.
Number
Yes, Your Lordship. Such posts shall be picked up strictly in compliance with the provisions of the AFA-RPM Act, the Reservation Acts relating to so-and-so and the other relevant acts and rules, ruling of so-and-so, and strictly in accordance with the valid service rules, due procedure established by law, etc. and after issuing advertisement in papers laid down. So therein also, my lord, the secretary's approval was required to be filled up, but that post to be filled up.
So your submission therefore is that as you were being paid your salary, there has to be a SLEC approval and you have no way to get it because you can't look into it. So the approval being there, which is required as per the 99 notification, was duly there.
It should be deemed to be. Otherwise, they, my lord, would not have released it. And after that SIU thing came into being, there was a rationalization. No, my lord, one doubt may just try to, my lord, remove. My lord, let's say that this whole thing is a bogus thing. This is a bogus thing. There was nothing, even not even there in the picture in 2005. Let's, my lord, for my satisfaction, my lord, remember. Now, these appointments were made subsequently, maybe 11, 12, showing back it. Because there was a sort of an argument at one point of time raised by my friends. Then, my lord, what would have happened is this post would have been vacant. These posts, the manner to be these posts would be filled up would have been within the purview of that committee. That committee would have come up and said that these are the vacant posts under the joint director so and so. This may be abolished and this number may be filled up. That is also.
No, as we are not into that.
No. I'm just trying to show it from the other angle.
So that is on the question of the 99 documents which they are saying about the SLEC. As regards the ban, you say that they have not been able to show as to when the ban ended. And as such, without being shown that, how can you say that the appointments were made during the ban?
It's an inference only there, 2006. But that 2006, the direction of the cabinet is of 7/3/2005, proximate to our appointments, and it says backlog vacancies. Now, if from 2002 to 2005, according to them, there was no recruitment at all, from where would this question of backlog arise? Backlog would arise only when a recruitment is made and the adequate number of reserve community candidates are not appointed, or they were not there. But I'm just trying to come to that.
Number 3,
Lordship.
is his submission that the joint director at no point of time had the authority. Is nullified by the fact that when that particular document was issued on 22/5/2002, there was a direction to the joint director not to appoint, meaning thereby there was a power being delegated.
Otherwise, the director ought not to have it. There was no occasion for the director to issue that letter. He was the appointing authority. But that letter itself shows, my lord, their contention that the joint director is not the appointing. All district officers head in the state are the appointing authority. At least for the grade 3 and grade 4. In all departments.
Well, not in the health department. It is a director now, not the joint director.
Now maybe they have.
Why have you made when? How did the director now?
Now means,
question,
my
how
lord,
did he come?
after, yes, my
If
lord.
he was all along the
No, there
appointment,
is a specific notification to that effect. It is a director who will make the appointment, madam. Any appointment. The district authorities, they don't have the authority. So maybe because of all this, my lord, that finally that decision was taken.
And the most interesting factor here, my lord.
And lordship will see the other cases.
Why
my
was
lord,
that
appointments were
notification-
issued by the director? My lord.
huh? Why was that notification issued? Only the director shall appoint.
Because of all these anomalies, my lord. Finally, now, my lord, every appointment, my lord, it is a director, my lord, will conduct the, my lord, selection and also, my lord, the final the appointment. To the director. Their decision, my lord, the government.
So anything else?
My lord, otherwise, my lord, I would like to place one or two judgment, my lord, why tokens in case, my lord,
What?
case, my lord, regarding the other cases. In
Only one
Gwalpara and
submission,
Dibrugarh, my lord, Gwalpara and Dibrugarh, my lord,
There only you require judgment.
yeah, here, my lord,
There
I'd
you
like to
don't
say-
want.
My lord, only one submission, my
Only
last
one.
submission.
Once an astrologer told me that you have these particular planets are in your favor. So you use these stones to make it more stronger. Don't act on something of a weaker planet which is otherwise weak. So why do you need a stone to make it strong? It is something to that effect.
No, my lord, one interesting factor here, this director, joint director, appointing authority thing. The termination orders were issued by the joint, not by the director.
My lord,
These things are
I'm only on the.
as far as my lord, Dibrugarh and Gwalpara is concerned, I would like to rely by token thing also, my lord, para 16, my lord. Probably I have given the copy of the.
why token sing.
Yes,
Yes, I have it. Tell me. Which one?
para 16, my lord.
What was the fact involved here?
Well, here, my lord, without any authority, the in charge director, he made some appointment. So that authority part, my lord, I like to point out.
Para 16. Issued in favor of the respondent hearing.
The
were
offers of
cancelled
appointment
entirely.
issued in favor of the respondent hearing were cancelled entirely on the premise that same has been done without the knowledge of the Revenue Department of the state. No records thereof were available in the state. As noticed herein above, herein before, an inquiry has been made wherein the state Sri Sayeng, the then Commissioner of Revenue, stated that no such appointment had been made to his knowledge. The state proceeded on the state basis. The offers of appointment were cancelled not on the ground that some irregularities have been committed in the process of recruitment, but on the ground that they had been non-est in the eye of law. The purported appointment letters were fake ones. They were not issued by any authority competent thereof. If the
No,
offers of
no,
appointment,
Mr. Buko, you don't require judgments for that. Yes,
Yeah.
you want to make the judgment beautiful by putting this. It's a different aspect.
Yeah.
There's no quarrel with those propositions.
Yeah.
But you want to show, you say that the joint director was never authorized.
yes,
Then why did you issue that letter?
my lord.
Why did you issue the letter directing joint director don't issue appointment? Why?
My
On
lord.
22/5/2002, why did you issue the letter to the joint director
Yes.
that don't issue appointment?
No, my lord. It is to be because, my lord, after, my lord, only this particular, my lord, ban period, my lord, whatever has been imposed by the government, it is necessary to be intimated to all the authorities. There is a direction of the government. It will have to be intimated, my lord. The SIU approval, my lord. SIU has come into being. It is to be intimated to all the departments that transport, you will have to do that. But
Understood.
just by making that, my lord, letter
No, no,
hasn't
no,
been
no,
made, he has
no.
been delegated.
You intimating the director, the joint directors,
My lord.
look here, there is a ban period.
Lord,
And as such, this director cannot issue appointment.
Lord.
That's a different thing.
Yes.
But you are asking them, don't appoint,
My lord.
as it is a ban period. Meaning thereby, are you not saying that you are otherwise, you can appoint?
No, of course they can appoint, but with the having that, my lord, delegation been given to them. my
So
lord.
that means
After every recruitment, before any recruitment, you will have to approach the authorities, my lord. For, my lord, having that power, my lord, having that permission or approval for appointment. Secondly, my lord, as per sub rule 3 of rule 5, you will have to, my lord, tick the, my lord, necessary eligibility criteria and whatever is there. And on top of that, my lord, the SLEC approval at that point of time.
no, that is another
No,
aspect.
it
But
is
the
the main
only
aspect.
thing
One.
is-
These three things are to be, my lord, done
So
by the
that
joint
means
director
there was
from
a delegation earlier.
delegation, my lord, it will have to be selection wise. It cannot be that in general somebody has been given a delegation, then he will keep on giving appointment without any approval from the government, my lord. There cannot be any appointment without the approval of the government, my lord. Whatever be the issue, my lord. At least, my lord, the subordinate authority will have to, my lord, intimate the authority that these are the posts lying vacant, we like to fill up. At least
But
minimum, my
Mr.
lord, that's all.
Gogoi, that submission, if I hold it, you will have a lot of problems, not here, everywhere.
But it is
Where you
necessary,
keep
my
on
lord.
getting appointments out there from the director of higher education, director of elementary education.
That's why, my lord, they are approaching this honorable court. They are not receiving a salary for months or
No,
years
no,
together.
not on that. You see, if you go to the Assam rules of executive business, more particularly Rule 12,
My lord.
says that whenever an order is passed under Article 166(2), 1 and 2 of the orders of the state,
My lord.
the power has been given to various secretaries, joint secretaries, deputy secretaries, and other officers. The directors are not given that power. But if you see all these orders of provincializations and all these things, these are being done by the director.
Right.
Pursuant to orders being passed by the government.
Government, yes.
So under such circumstances, when the director is doing out there, if we just hold it, what you say, that it has to be specific
Sure.
to each selection. I am not saying that every time there has to be a delegation.
But in the present case, my lord, ultimately the present director who has drawn this affidavit, he will be relying upon the records available in the director.
He had no records, it's a different thing.
So,
That
my
is
lord, there
another
is
aspect.
nothing to show that, my lord, that power has been delegated to the joint director Gwalpara or Dibrugarh for making the appointment. Something will be there, my lord. There's no point of hiding that. We have searched the record, nothing is there. That's why you have stated in the affidavit that there's no such record whereby the power has been delegated to the joint director. He can make, my lord, provided the delegation is there. And, my lord, it is the duty of the director, if a government says that, my lord, there is a bench period, to intimate every authority in the district that this is the position. Others, they will say that, my lord, they are not aware. Like in the present case, some RTI reply, now the director, joint director says that, my lord, as per records available, it is not there. Even, my lord, regarding the bench period. It is a duty, my lord, he will have to convey to the all the authorities.
Okay, then Yogan Singh looked into. Then
Yes.
what is
My
this
lord,
Devendra Sharma?
same is the case in, my lord, Devendra Sharma, my lord, 2020 15 SCC.
Hmm.
Here also, my lord, the issue is regarding, my lord, the delegation of power only, my lord. Lordship will find it, my lord, in para 22. 20 to 23.
22.
22.
Yes.
And, my lord, para 17, Lordship will see the issues that were framed, my lord.
Hmm.
Number 3, my lord.
Appointments made by a person who was not competent to make the appointment. They are serial number 5229. Yes. Now coming into the second category, we are concerned with category number 3.
Three.
3. Coming to the third category, paragraph
Third category.
20.
Para 20 onwards, my lord.
Uma Devi. Then Uma Devi. Then
Para 22.
paragraph
The
22.
state committee has examined all the appointments and segregated appointments based on false documents and also irregular appointments. Irregular appointment. Once the detailed report has been submitted examining the merit of his candidate and when the judgment of this court in Ashwini Kumar and Uma Devi conclusively answers the question against the employees, no further discussion on the argument raised to survive. However, these arguments have been addressed in respect of third category of cases, appointment made by a person who was not competent to make the appointment. We shall consider as to what will be the effect of such appointment. So now, we will find that in para 36. And 41.
Hmm?
36, 41. 41, my lord, it will suffice, my lord, may I read it? This court in the Union of India versus Raghuvar Pal Singh was examining a case where the appointment letters came to be issued without approval of the competent authority. Then whether such appointment letters issued to the respondent would be a case of nullity or a mere irregularity. If it is a case of nullity, affording opportunity to the incumbent would be a mere formality, and non-granting opportunity may not vitiate the final decision of termination of his service. This court held that in the absence of prior approval of the competent authority, director in charge could not have hastened issue of the appointment letter. The act of commission and omission of the director in charge would therefore suffer from the vice of lack of authority and nullity in law. And my lord, that also I have relied upon, but it is already been quoted here. And in Mamta Mohanty's case, my lord, the 11.3 STC 436.
Which
Here,
one?
my lord, Mamta Mohanty's case, my lord, serial number 4 of my book list. Here, my lord, it has been categorically laid down.
Mamta Mohanty, I don't find it.
My lord, I have got it. Para 35.
Okay. Yes. This is appointment without advertisement.
Yes. Sir. In all the other cases, my lord, except my lord, Gwalpara and Dibrugarh, there is no such advertisement and selection held. So, my lord, this particular, my lord, ratio laid down by the Honorable Supreme Court in my lord Mamta Mohanty's case will suffice, my lord.
What does it say? Does
At
it
one-
say the appointment to be irregular or illegal?
Well, yes, let me, my lord, read it. At one time, this court has been of the view that calling the names from employment exchange would curb to certain extent the meaning of nepotism and corruption in public employment. But later on, it came to the conclusion that some appropriate method consistent with the requirement of Article 16 should be followed. In other words, there must be a notice published in the appropriate manner calling for application, and all those who apply in response thereto should be considered fairly, even if the names of candidates are requisitioned from the employment exchange. In addition thereto, it is mandatory on the part of the employer to invite applications from all eligible candidates.
As per the 97, how many persons can be appointed against means normally selection is made, a select list is prepared.
Yes.
Does the 97 rules stipulate the number of persons who can be brought within the select list against the vacancy? No.
That is not the case.
Like in many other places, you find twice the number of vacancies.
Yes,
or
sometimes it is 1:2 or 1:3. That, my lord, in many cases, my lord, it is the selection committee who takes the decision. According to the, my lord, number of applications received. If it is more, my lord, then it is 1:2. If it is less, it may be 1:2.
No, it is mentioned out there in the rules.
In some rules, it is mentioned. Otherwise,
Here it
a
is not there.
My lord, may I read it?
Even if
the names of the candidates are requisitioned from employment exchange, in addition thereto, it is mandatory on the part of the employer to invite applications from all eligible candidates from the open market by advertising the vacancies in newspapers, having wide circulation, or by announcement in radio and television as merely calling the names from the employment exchange does not meet the requirement of the state article of the Constitution. 36. Therefore, it is a settled legal position that no person can be appointed, even on temporary or ad hoc basis, without inviting application from all eligible candidates. If any appointment is made by mere inviting names from the employment exchange or putting a note on the notice board, etc., that will not meet the requirement of Article 14 and 16 of the Constitution. Such a court violates the mandate of Article 14 and 16 of the Constitution of India, as it deviates from as it deprives a candidate who are eligible for the post from being considered. A person employed in violation of this provision is not entitled to any relief, including salary. For a valid and legal appointment, mandatory compliance with the state constitutional requirement is to be fulfilled. The equality clause enshrined in Article 14 requires that every such appointment be made by an open advertisement, as it enable all eligible persons to compete on merit. And my lord, the regulation part, my lord, 37, possibility 38, my lord. The concept of adverse possession of lien on post or holding over are not applicable in service jurisprudence. Therefore, continuation of a person wrongly appointed on post does not create any right in his favor. My lord, simply, my lord, merely stating that, my lord, for this long period I am working, So that will, my lord, not create any right on a person.
That is has been held in Uma Devi.
Yes.
But the only difference is adverse possession.
Adverse position.
12 years.
Adverse position. Then Aligarh Muslim University, my lord, that proposed notice part.
Yeah,
That, my lord,
And that has already been there in that judgment, no?
Devendra
That Devendra Singh
yes, sir.
says that. If it is illegal, then the means it is. If it is a illegality, there is a requirement. But if it is a case of an appointment
My lord,
by an authority who is otherwise not competent,
Lordship.
then it is not required. It comes within the ambit of useless formality.
Lordship.
Aligarh.
Well, that, my lord, judgment that other day Lordship referred to Jammu and Kashmir, my lord, and district by association.
Oh, that, yes.
26, my lord.
But if
That part, my lord, I have gone into. In fact, my lord, there also, again, my lord, may I read the para 26 last later part. The formulation of such a scheme cannot be accorded the status of an enforceable right. It would perhaps be prudent to leave it to a claimant to establish whether he or she falls within the exceptions carved out in para 53 and falls within the ambit of a scheme that may be formulated by the state. Subject to the writers referred to above, a scheme of regulation could fall within the permissible limit of Uma Devi 3 and P after. So again, my lord, these three conditions will come in, my lord. If at all, my lord, the other in other cases, Lordship stated that whether
No, these
government
judgment
can,
make two very, very vital aspects of the matter.
yes, sir.
One is you can regularize something which is irregular, not an illegal. The second is regularization is not a mode of recruitment.
That
So
is
you
what
have
Uma
to
Devi-
apply once. Therefore, regularization is a policy,
is a policy.
and on the basis of the policy, you have to apply the rules for it.
Yes.
Otherwise, then if we are to consider regularization, which you have already, your state have flouted it right, left, and center, it's a different thing. But if we consider it, the regularization to be a mode of recruitment, wouldn't that touch on Article 14 and 16?
Yes, well, that in fact that's why, my lord, the para 53 is an exception, my lord, given by the constitutional bench of the honorable.
Because then you don't need to follow the rules. You don't need to go for an advertisement. You can just pick and choose whoever it is. Therefore, it has been made that paragraph 26 is very relevant. Yet that you cannot regularize something which is illegal. You can
And
only
even-
regularize something.
That's why, my lord,
illegal.
in this particular judgment only there is where I found one statement of the apex court that, my lord, one who enters from the back door will have to leave from the same door. So natural justice and all, my lord, is otherwise not necessary.
Yes. Anything else? You have any judgment?
no, my lord, I'm only rely on Mohinder Singh guilt to show that you cannot develop your case after coming to the court. And my lord, what the judgments that my friend have taken will have no application in the two cases of Dibrugarh and Golf. Other cases, my lord may consider that. But here,
Understood. Mohinder Singh Gill or Govardhan,
Govardhan,
they make it very that our order has to be tested on the basis of the reasons stated. Here, the reasons is the ban period as well as another
the director's approval is
SIU
also-
approval and all this thing.
SIU is not required.
For that, it is okay that this particular, what can this court do if that is so? Court can only remand it back
My lord, here they have
for a
not been,
decision.
here they have not been, my lord, able to establish their stance. At least that 2002 letter.
No, no,
shows that it
therefore,
has-
there,
Because my lord, they have got nothing.
Huh?
They have got nothing in their hands to demolish the, my lord, the stand that I'm trying to place before my lord. Going there would be an empty formality. They'll just reiterate this thing.
so therefore,
I have shown.
but if that be so, I can't leave them and say that no, you have not mentioned out there, so you are stopped or a res judicator will apply. You
No,
can't
no, no.
raise this issue
No,
or an estoppel is due.
no, my lord. If they want to raise an issue, my lord will remand back the matter. I'm just holding. I love my lord if my lord wants to say because they have not been able to show anything. But my lord, tomorrow my lord is remanding back the, let's say Dibrugarh and Gwalpara. For example, my lord is remanding back the matter. Then my lord, it should not be a general direction. It should be an individual thing. Because now I am there, they cannot ignore Article 311. If they have to do, they'll have to do in a procedure. Because this, my lord, perfunctory exercise, my lord will not perform. If they have to do,
No,
They have to do under 311.
The illegality is different thing, man.
because my lord, there is-
311 will only come when your appointment is legal.
no, my lord, for all intent and purpose as on date,
No,
my lord, my appointment should be deemed to be legal.
Absolutely.
any
That,
doubt-
that would have been a case if I would have considered his, you allow me to consider his submission and then remand it back. But if I'm not considering his submission, I'm only setting aside that order of your termination
Right.
only to the extent that you have not taken into a consideration these aspects of the matter, but these are various other aspects which you get liberty to do so. That is another aspect of the matter, which there you can't bring into
Lordship,
your 11.
Lordship, if that, then my lord will also, my lord, if my lord is interfering with the transfer, the
And
termination
that I
order.
have not thought
No,
about
no, no,
it.
my lord, either way, we are just making, I'm also not, my lord, saying my lord will do that.
but
Then my lord, my salaries have to be released and I should be reinstated.
in that event, my lord, regarding salary part, this honorable court in a similar case, my lord, where my lord, we could not issue the so-called notice properly. Lordship has already observed that in para 6, my lord, I would like to say.
That, my lord, is maybe a different thing altogether.
No,
That
no,
is
no,
education
same
department.
issue, it was reverted
Education
back
department.
para 6. my lord.
Education.
No, no, health, same scrutiny committee, my lord, report. So-called were not properly issued. Para 6, finally, Lordship has
My
said,
lord,
my lord,
that stage is over here.
so Lordship will see the para 6 only, my lord, only on that point. If they are found genuine, my lord, they will be paid the salary. my lord. We will conduct the, my lord, inquiry within a time frame.
So these are matters pertaining to those people who always comes before this court and say that you have not, and you have also duly admitted that the joint director did not issue the
No,
so-called
my lord,
properly.
my lord, this particular, my lord, case, my lord, that I placed arises from the same scrutiny committee report.
Understood.
specific, my lord, deficiency,
Mr.
my
B.
lord,
Gogoi, kindly listen.
My lord,
When this matter came up thrice.
yeah.
On
No, no, I'm not saying
on
I'm
the
regarding
first
the-
date, you said that we have been instructing the joint director to do the needful and issue the notice stating these.
Hmm.
Then you state that on the second date, I will further inquire. On third date, you came up and said that look here, they have not, we are going to issue fresh notice stating all these things. So you quashed it and allowing
Final order.
My lord, yes.
And those
Only,
stages are over.
only on the salary part, my lord, I think.
those salaries and all.
Subject to, my lord, what lordship finally decide.
My prayer would be, my lord, would
If it goes,
at least in these two cases, my lord, interfere with that. Because at least from 13 years, my lord, they have done this. And 13 years shows that those were irregular. And my lord, that SIU exercise.
if required, I can place the, my lord, AFFM X also, lordship can keep it, my lord. That's my other cases.
And on the lighter side, there are, my lord,
FRBM.
Here, my lord, the section 5 prescribes everything.
my lord, on the lighter side here, there are, my lord, I think 3 or 4 people, my lord, who were very young at that point of time. Because of this job, they got to get married. 3 or 4. Follow political.
But Mr. UK Knight, a learned senior counsel, assisted by Mr. R. Sinha and Mr. P. Gogoi, the learned standing counsel for the Health and Family Welfare Department. You are there?
But that item may be segregated, maybe. We are yet to file our affidavit.
Hearing completed, judgment served. Hey, item number 14 to তেওঁ এতিয়া কৰা নামটো heard Mr. Swenso and Mr. B. Gogoi, the learned counsel appearing on behalf of the Health and Family Welfare Department. Mr. Gogoi submits that he requires one final opportunity for filing the affidavit.
Lawsuit is concluded in that.
No, that is matter.
Yes, yes, in item 14, of course. Yes. we'll
One
file-
final
We'll
opportunity
file
for
on it.
filing the affidavit. Taking into account the same, let the affidavit be filed by.
Let's
After
see,
4
after
weeks.
3 weeks, 4 weeks. Because this
I won't say
order-
anything much because these matters have gone out.
My lord, only thing, in the other cases, not these two cases, my lord, there was a similar situation in surveillance workers. The learned single judge, my lord, interfered with the matter and the division bench it went. Division bench, my lord, remanded back the matter to the authorities, my lord, for a fresh consideration.
My lord, that
Just
part,
placing it subject to
No.
what.
that part, my lord, I was present, my lord. In fact, the counsels appearing in the division bench, they praised her that, my lord, they have got genuine documents. The Honorable Court said that, my lord, we will not interfere with the judgment of the learned single judge, but we are giving a final opportunity, we appear, provided that if something it comes up that, my lord, your fraudulent documents have been placed, immediately FIR will be lodged and you will be put behind bars. Nobody appeared, my lord. The committee kept for 50 days, nobody appeared. That I can place it on record. Nobody appeared. All were fake.
Much obliged.
Yes.
The last page of 2 documents were called for. That the office note reflects that this document has not been yet received. Office note 323.
What document? Page?
Document. First, court order dated 4/5/23. In fact, it was hard to some extent. During the course of hearing, it was
You are, what is the case about?
this is the underside. They have filed a suit for specific performance of contract. It was proceeded expert. And later on, I came to know about the suit because there is a paper publication, it has been accepted. When I came to know, I filed an application before the court below. Before the court below, I have filed an application under Order 9 Rule 13 along with a petition for condonation of delay. That was rejected.
So you
Thereafter,
have challenged it here. You have challenged it here.
thereafter, Order 43 Rule 1B alert. Appeal alert. That was also this. Now, this particular.
So what's your point?
The point is regarding publication of paper publication. My point is that there is a delay of 120 days. But paper publication was made 13/7/2018. It was published in Lakhimpur edition. Assamia printed in Lakhimpur edition. The deed which they put for specific performance. My address is I am a resident of the Guwahati. Although my ancestral home is at Lakhimpur,
It was published in which news?
Akomia Protidi. That is Lakhimpur edition, not Lakhimpur edition.
Not Lakhimpur edition does not include those publications.
No, I am residing for my avocation. For my service, I am residing at Guwahati for many long years ago. That was not circulated in Guwahati. And even then, the paper publication. For the purpose of it, because it, another round is the footnote. The proviso.
You had an agreement? Did you have an agreement?
There is an agreement. On the basis of that agreement,
Are you denying the agreement?
perhaps that was there. At this,
Are you denying the agreement?
that specific requirements is not on record.
No, I'm asking you, are you denying the agreement?
That has to be taken because that is at this moment.
What is your ground for setting aside that you were not served?
Number one, it was not served, and before resorting to substituted service, there are some mandatory provisions. That has not been complied. Even the process server was not accepted.
Process server for what?
First, before resorting to public paper publication, there is a it was served by process server. There is a report of process server that nobody, he went to the address and he found nobody there.
Now, did the court accept it on the basis of process server or did they?
Yes, process server report was accepted, and thereafter, on the basis of this particular petition, which is the last protocol for, on the basis of that petition, Lordship, the report was accepted. The paper publication was accepted.
So thereby the court not only did not believe or take into account the provisions of Order 9 Rule 6, but went into a further mode which is required under Order 5 Rule 20 of substituted service. Now the substituted service was published on 5/8/2018. At that point of time, that paper publication was there.
Paper publication was.
When did you know about the paper?
When they have filed a case for execution, that particular, the notice was served upon one of my relatives. From him, I came to know. I have specifically mentioned.
Show me that statement where when did you? It will be there in your application for Order 930. Kindly come to paragraph number 5, 6 of that page, at page 43.
Page 43. Paragraph 5,
Paragraph 5 is
and one is the our first paragraph. There is a line. Came to in the month of September 2009, came to know about that title execution proceeding has been initiated against the petitioner
that is
defendant.
a different thing. We are not on that. I'm saying about paragraph 5 and 6. Paragraph 4. Came to know to the record of title suit number Iman that on the basis of the publishing of accounts in the local newspaper, Akomia proceeding 5/8/2016 by way of advertising this was to hold that the summons was duly served upon the defendant. And since the defendant had not taken any steps for filing written statement and directed the suit shall be
paragraph 8 is specifically said.
Who entered into the agreement? Did you execute the deed of power of attorney?
One power of attorney was like,
What was the address put in the power of attorney?
certificate is there. But parallelly, at that power of attorney, certificate was not on record.
I'm not on that, but what was the address put in the power of attorney by you?
Sorry.
What was the address put in the power of attorney by you?
Both address are there. Lakshmipur as well as Guwahati.
Then why did you put two addresses?
So even then, Lordship, whether I have the knowledge, in spite of having service on notice, or in spite of having my definite knowledge about the title, so I have neglect to appear. That is the Lordship practice. Because paper publication 120.3 Limitation Act, even in that it is specifically for the purpose of that one article 123
Article 123 is a case of fraud, isn't it?
no, limitation act.
Limitation for what? From the date of knowledge?
Yes.
From when? Not from a decree. From a
No,
decree
it-
passed fraudulently.
No, but from the date of knowledge,
Read 123. Let us hear what is 123.
set aside expertise, decree pass, set aside a decree pass expertise or rehear an appeal decree or hard expertise. 30 days, the date of the decree where the summons or notice was not duly served. When the applicant has knowledge of the decree, The explanation is there for the purpose of this article, substituted service under Rule 20, Order 5 of the CPC shall not deem to be due service.
Then
The date of my knowledge is I have specifically mentioned.
when did you come to know about the decree?
It is in the month of September 2000.
There is no mention in your application on the Order 9 Rule 13. And you say it to be true to your knowledge.
But in the application,
In your application at page 43, there is no date when you came to know about the knowledge.
is there, or in this particular copy, it is not there because it is not-
How can there be a different copy? Is it your case that you have enclosed a different copy of the
No, Lord,
affidavit, of
it-
the Order 9 Rule 13 application?
same copy, but
Then
no, same copy, Lord. Date is here, it is keeping blank, Lord.
no, there is no blank. The document which you are enclosed out here, that has to be taken into account.
Lord, it will come to page 47.
At least come to
Lord, which
this.
is 5,
You
9,
say
5,
that
9,
you have come to know at page 52
Lord,
on 5/9/2019.
yes, Lord. Page 48, 5/9/2019. That is
And
this
when did you file it? 30 days.
beyond 30 days. That is why application.
You filed it on 3/2/2020.
Yes.
Then why? What is the delay there?
But-
Why there has been a delay?
There is why the application order section 5 of Limitation Act is there.
Understood. But merely by filing an application on the server, is it a right vested upon you to get the delay condoned?
No, Lord.
What is the reason why you couldn't file it?
The reason is on after knowledge, Lordship. The reason is that he has some health complication and he is under treatment. That is why he is immediately not coming.
Your health complication was from 2/2/2018, as could be seen here. You have only mentioned in your application. You were under health complication from 2/2/2018. Kindly see paragraph 8, page 54.
To 2008.
Then how did you know about it? You were all along from 2/2/2018 prior to the service, because the service was affected on 5/8/2018. Prior to that also, there was ailment. You knew about it on 5/9/2018-19.
592.
So what was different from 2/2/2018 and the date of filing? Was there any medical documents to that effect?
One certificate was submitted.
Show me, where is the medical certificate?
It is not on record.
Why? How can this court be satisfied with all these things unless you produce those things on record? Huh? Do you have the agreement?
My lord, your lordship kindly see very two important document like doctor certificate and the power of attorney where the address is given from the Lakhimpur itself. That was withheld, and I have last occasion I have given to your lordship. I don't know whether it is there. My lord, once again I will be
in the
giving
last,
you. Now, doctor certificate, my lord, your lordship may see that I am
both are there, Lordship, in the original file below down.
Original file has been- There's only one file. Oh,
Just
yes,
above the-
doctor certificate.
my lord, it is stated that is a
There's
heart
no
patient.
date mentioned. Certified that Mr. Thiok Chondro,
Above
born on
22/120.
about 60 years, male, was therefore sick of heart ailment in so and so under my treatment with effect from here. after full medical supervision, he is advised to be completely bed rest. What is the date of this document?
22/1/20.
Now, Your Lordship kindly see, he's a child specialist. Your Lordship kindly see, Dr. C.S. Bhattacharya, MBBS DCH. Now, he's a heart patient. He's gone to child specialist. And even this doctor, my lord, is a fraudulent document, Your Lordship kindly see. He has said he has been under his treatment from 2 to 2018. And the rest, he has asked that after full medical supervision, he is advised to complete bed rest. That is from 22/1/2022, 20, on which he has stated on
This
these dates,
document is half. I don't have half of it. After full medical supervision, he is advised to completely
bed rest.
bed rest, that is out of any service.
Now, his statement in the petition, he
Hmm.
has been recovered on this date. And the doctor is saying that he will have to be in complete bed rest. Now, Your Lordship kindly see the page 10, paragraph 10 of the petition, my lord. Civil division petition. Page 10, paragraph, my lord, the middle part, Your Lordship will find. It was in the latter part of the month of January 2020, after recovery from his illness.
And what is this about the North Lakhimpur thing?
That Your Lordship kindly see. The power of attorney which is
That I've
given.
seen it. It is there.
Yes,
Which-
now
which is
address,
that?
Your Lordship will find this present residing at ward number 14, North Lakhimpur. Relating to this particular land, this power of attorney was given to my husband for selling of the land.
To your husband.
My lord.
First is the with whom the agreement was executed.
The agreement was between the petitioner's husband with the plaintiff's husband.
Plaintiff, not
The plaintiff
Wife,
and the
wife.
plaintiff's husband.
plaintiff wife. Agreement was with plaintiff wife, and power of attorney is with plaintiff husband.
Understood. So the agreement was entered into between the plaintiff's wife, plaintiff and the plaintiff's husband on the basis of a power of attorney executed on so and so.
Agreement is between the respondent and the petitioner. That is,
Agreement was entered. Where is the agreement?
agreement Your Lordship will find at page 27.
20?
7.
He says that he doesn't know about the agreement. Why? Let me say this. But in the agreement, the address is mentioned to be at
Guwahati.
Nurmati Guwahati.
Yes.
then
Now, Your Lordship can listen the power of attorney.
understood. But was the power of attorney used for the purpose of that agreement?
And
Yes,
Lordship,
now, even he has stated in the impugn order, Your Lordship will find, he is saying that the temporary address at Lakhimpur, that
No,
Your
no,
Lordship
no,
will find at page.
that is a different thing. But in the address, it was when the agreement was at Guwahati. Why the address in the plaintiff was mentioned as that address at Lakhimpur, not Guwahati?
Because my lord, we have relied on general power of attorney.
But the
That
general
address-
power of attorney is not the basis
Not
on
a
which
part-
the execution.
even
Mr. Counsel,
Lordship,
the general power of attorney was never the part of that agreement.
My lord, your lordship, if your lordship kindly see at page
29,
59,
page 29.
page 57, your lordship kindly see at para 4. We have annexed the copy of this document.
Which one?
At page 57, para
No,
4.
that is a different thing. But who signed this agreement?
This
Page 50, page 29.
page 29, my lord.
Who signed this agreement?
This is by Trilak Chandra Bhuya and Khemu Kumari Devi.
So that means, and there the address has been mentioned of the plaintiff or the defendant, the petitioner herein to be dead at Guwahati.
Guwahati.
Then why in the suit only that this Guwahati address was not mentioned?
That is not mentioned in the suit, the address of
Then don't you think that it is not correct? When you are basing your entire case on the basis of the agreement. The agreement I would have understood had made the basis also on the power of attorney could have drawn the inference. But why was it necessary to do it in this manner?
power of attorney in the we have this particular power of attorney is a part of the record also.
Understood, but this agreement on the basis of which you are speaking, seeking specific performance,
Yes.
does not use that power of attorney.
Of course, it's not.
Then,
But then we have explained it while they have filed an appeal. We filed our objection. We have annexed that particular power. of attorney.
understood, but merely because I have executed a power of attorney stating I am also a resident out there, maybe for some purpose I may do it for the purpose of selling of the land.
For this land. This-
Absolutely,
this
for
land.
selling of this land, I may put my address out there. But would it mean that my address would be there? When my agreement was specific, you have to do it on the basis of that agreement, not on the basis of power.
That way your lordship is correct. But then they have admitted, if your lordship see the MP in order, I will just take your lordship to that.
The certain procedural aberrations has to be,
That is your lordship is very right.
they shouldn't have filed it. I would have understood. They're filing the suit, putting an alternative address also would have done. But I would have understood if that power of attorney that your husband have executed the deed of sale, agreement for sale on behalf of this petitioner on the basis of the power of attorney, and then on the basis of that agreement of sale, he goes out there. I would have understood. But this agreement for sale under no circumstances contains the address at Lakhimpur.
That's very correct. I accept
So
that.
that
my
is
lord.
a fair thing.
But then your lordship can say at page 62, just for a while.
Yes.
Now, in the middle part, the defendant petitioner submits that he is a permanent resident of ASCP colony in Nurmati, Guwahati. He is a temporary resident of Lakhimpur district also.
Where?
Now, therefore, in the middle part at page 62,
That is not
Two.
my
The
that is the
defendant petitioner,
observation made by the court below.
defendant petitioner
Page
submits that
52 is different.
62.
62.
Oh. Yeah.
Line about 8, my lord.
Hmm.
The defendant petitioner submits that he is a permanent resident of SCP colony Nunmati, post office Narangi, Guwahati, Assam, and he is a temporary resident of Lakhimpur district. So, my lord, he is
Now, next
also
line, Lord.
accepting
The
that
plaintiff,
position.
in spite of having knowledge of his permanent address,
Yes,
did
what
not-
is your name, Mr. Counsel? Utpal Datta. Heard Mr. U. Datta, the learned counsel, appearing on behalf of the petitioner. Mr. S. Datta, the learned senior counsel, appears on behalf of senior counsel, assisted by, appears on behalf of the respondent. The instant application under section 115 of the Code of Civil Procedure, for short, the code, has been filed challenging the judgment and order dated 11/11/2022 passed by the learned civil judge Lakhimpur, not Lakhimpur, in Miss Appeal number 02/2022, whereby the appeal filed by the petitioner against the order dated 23/3/2022 passed by the learned Munsif number 1 North Lakhimpur in Ms. J case number 18/2022, dismissing the application under section 5 of the Limitation Act 1963 for condonation of the delay of 120 days in presenting the petition under order 9 rule 13 of the Code of Civil Procedure of the Code was rejected. From a perusal of the said document, from a perusal of the materials on record, it transpires that an agreement for sale of a plot of land measuring 1 Katha 10 Lecha covered by Dag number 1338 of Patta number 402 of North Lakhimpur town, bracket part 1 Moda Lakhimpur, was entered into by the petitioner with the respondent on, what is the date? 25/6/2016. A registered deed of agreement. Huh? It is relevant to mention herein that in the said registered deed of agreement, the address of the petitioner was specifically mentioned at ASEB Colony, bracket part, within PS Nunmati, district
Kamrup Metro.
PO Narengi, Guwahati, in the district of Kamrup Metro, Assam. The said deed of agreement has been enclosed to the instant revision application as annexure. What is this? Annexure D. On the basis of the said agreement for registered deed agreement for sale and for non-compliance of the same, a suit was filed on 26/4/2018 by the respondent herein against the petitioner, which was registered before the court of the civil judge, Lakhimpur, North Lakhimpur, which was registered and numbered as title suit number 9/2018. In the same suit, the address of the petitioner was mentioned as resident of ward number 14, comma, PO Kelmati, PS North Lakhimpur in the district of Lakhimpur. At this stage, this court finds it relevant to take note of that the said suit was for specific performance of the agreement for registered agreement for sale dated 25/4/2016. However, for reasons best known, the plaintiff oblique the respondent herein did not find it relevant to put the address of the petitioner as mentioned in the registered deed of agreement, but rather gave an address at North Lakhimpur. The records further reveal that summons was issued by the court, by the learned trial court, and on 13/7/2018, taking into account that the summons were not duly served, an application was filed by the respondent oblique the plaintiff in the suit for effecting service in substituted mode as mandated under Order 5 Rule 20 of the code. It reveals further that the learned trial court granted the permission on 13/7/2018, and thereupon on 5/8/2018, the summons were duly published in the newspaper Ohomia Pratidin. On the basis of the said summons being served, the learned trial court proceeded with the suit by deeming that the service upon the defendant oblique the petitioner herein was complete. It further appears that on 14/12/2018, the learned trial court decreed the suit in favor of the plaintiff, thereby directing the defendant oblique the petitioner herein to execute and register a deed of sale in favor of the plaintiff in respect of the suit property on accepting the balance amount of rupees 1 lakh. The further materials on record showed that the petitioner herein filed 2 applications on 3/2/2020. One of such application was an application under Section 5 of the Limitation Act 1963 for condoning the delay of 120 days, condoning of the delay of 386 days for setting aside the ex parte judgment and decree. The other application so far was an application under Order 9, Rule 13, read with Section 151 of the Code for setting aside the ex parte judgment and decree on the ground that the service was not duly effected upon the petitioner. Why it became 120 days?
It was wrongly mentioned. 120 days is in fact there the delay. The delay is 120 days, but in fact the calculation was made wrongly at 120.
The learned counsel for the petitioner submitted that while preferring the application under Section 5, on account of the wrong advice, it was mentioned that the delay was 386 days. Rather, the delay was only 120 days. To the same application under Section 5, the respondent herein had filed a written objection. In the same written objection, it was mentioned that in respect to the same plot of land, the petitioner had also executed a registered power of attorney in favor of the husband of the respondent on 3/12/2016, wherein it was mentioned that the petitioner's address, wherein two addresses of the petitioner was mentioned, one at Guwahati and the other at Lakhimpur, not Lakhimpur. The Lilith Trial Court, by an order dated 23/3/2022, rejected the application under Section 5 on the ground that the delay of 386 days was too long a period which cannot be condoned. The Lilith Trial Court further took into account that as the suit property was situated at ward number 14, North Lakhimpur, an issuance of summons by way of paper publication in Ohomia Protidian Lakhimpur edition was presumed to be at a proper place publication for notice upon the defendant petitioner. The claim of the defendant petitioner that he was unaware of the paper publication cannot be accepted. The Lilith Trial Court further disbelieved the medical documents so submitted by the petitioner. That he was incapable of filing the application. Within time. in view of the dismissal of the said application under section 5, the petitioner's application under order 9 rule 13 also is to dismiss. Next, the petitioner being aggrieved and dissatisfied prepared an appeal before the court of the civil judge Lakhimpur, which was registered and numbered as Miss Appeal number 2/2021.
22.
Huh?
2022. But
Mr. Doctor, kindly come to page 67.
covered with, but we already 69 because
Hmm?
perhaps by mistake they have written page 69 heading Miss Appeal number.
Registered and numbered as Miss Appeal number 2/2022. By then order dated 11/11/2022, the first appellate court rejected the said application. Appeal. By coming to a finding that the petition, that the substituted service so affected under order 5 rule 20 was properly done, and further disbelieving the medical evidence so produced that the petitioner was not capable of filing the application filing the application under order 9 rule 13 within the period of limitation. It is this order dated 11/11/2022, which is the subject matter of the instant revisional proceedings. From a perusal of both the orders passed by the learned trial court as well as the first appellate court, learned first appellate court, it transpired that both the courts took into consideration that the delay in approaching the court for filing the application under order 9 rule 13 was 386 days. The said period was taken into account on the basis of that the service upon the petitioner was duly effected in terms with order 5 rule 20. The learned counsel for the petitioner submitted that as the service was not properly effected, the period of limitation would therefore count from the date of knowledge of the decree, which was on 5/9/2019, and for which the delay was only 120 days. This aspect of the matter can be seen from Article 123 of the first schedule to the Limitation Act 1963, which stipulates the period of limitation for the purpose of, where is the limitation? Yes, you give it to me. I removed the glass at last.
It's part of
But that part
Why
has
don't-
to be,
okay.
otherwise the entire structure will. And there, for safety also. Illegal. 123 of the Limitation Act of the first schedule to the Limitation Act of 1963, which stipulate that for the purpose of setting aside a decree passed ex parte or to rehear an appeal decreed or heard ex parte, the period of limitation is 30 days from the date of the decree or where the summons or notice was not served, not duly served, when the applicant had knowledge of the decree. Therefore, the relevant dates for the purpose of the instant adjudication would be (14 12 2020) uh, 14 12 2018, which would be the date of the decree passed in title suit number 9/2018. The statement made in paragraph number two and 7 in the applications under section 5 of the Limitation Act, wherein the petitioner mentions that he came to learn about the decree on 5/9/2019 and on 3/2/2020, when the application when both the applications under section 5 of the Limitation Act 1963 as well as the application under order 9 rule 13 of the code was filed, were filed. In the backdrop of the above, let this court first take into consideration as to whether the service was duly effected, whether the substituted service was in accordance with the provisions of Order 5 Rule 20. There is no denial to the fact that the publication was made in the Lakhimpur edition of the Assamese vernacular newspaper, Assamia Pratidin. And the said advertisement, said publication was not there in the Guwahati edition of the vernacular of the said newspaper. Order 5 Rule 20, as already stated here in above, the address mentioned in the registered deed of agreement of the petitioner, that is the defendant, was at Guwahati and not at Lakhimpur and not at North Lakhimpur. However, in the plain, the address was mentioned to be at Guwahati, mentioned to be at North Lakhimpur. The address of the defendant, oblique the petitioner, was put at North Lakhimpur. Order 5, Rule 20. Order 5, Rule 21, bracket A. Categorically mandates of the court, categorically mandates that where the court acting under subrule 1 of Order 5, Rule 20, orders service by way of advertisement in the newspaper. The newspaper shall be a daily newspaper circulating in the locality in which the defendant is last known or to have actually and voluntarily resided, comma, carried on business or personally worked for gain. Therefore, the land, which is the subject matter of the dispute, being situated at North Lakhimpur, had no relevance with the advertisement to be made in the newspaper. The newspaper wherein it has to be published has to be a daily newspaper circulated in the locality in which the defendant is last known to have actually and voluntarily resided, carried on business or personally worked for gain. The address mentioned in the agreement for which registered agreement for sale dated 2022, in respect to which the specific performance of the contract was sought for, duly mentioned the address of the defendant to be at Guwahati. Under such circumstances, the service could not have, therefore, under such circumstances, taking into account that the Lakhimpur edition, under such circumstances, the advertisement, as the advertisement was there in the Lakhimpur edition of the newspaper, Asomia Pratidin, and the said advertisement was not there in the Guwahati edition of the said newspaper, the acceptance of the service being made by the state, the acceptance of the service by the learned trial court on the basis of the said publication through substituted mode was not proper. And accordingly, the question of the service being affected upon the petitioner oblique the defendant could not have been accepted by the learned trial court. In fact, it would have been the duty of the learned trial court also to have looked into and inquired, more particularly when the suit was for specific performance of a document wherein the address was mentioned at Guwahati and not at Lakhimpur, which was, however, not done. in that view of the matter, as the service was not duly effected, the period of limitation under Article 123 of the code of the first schedule to the Limitation Act 1963 has to be reckoned from the date of knowledge of the judgment and decree. Accordingly, the delay, therefore, and accordingly, as it is the stand of the petitioner, specific stand of the petitioner that he only came to know on 5/9/2019 about the said judgment and decree passed ex parte against him. And there is no specific denial to the same. It has to be therefore reckoned that it is on 5/9/2019 the petitioner had knowledge of the judgment and decree passed by the judgment and decree dated 14/12/2018 passed entitled suit number so and so. In that view of the matter, the delay which was there was only 120 days. Now, coming to the question as to whether the courts below had rightly exercised their discretion not to condone the delay, as Section 5 is a discretionary jurisdiction of the court. This court is of the opinion that the basis on which the learned courts below have decided was on the basis that the delay was 386 days. And on the basis thereof have decided that the delay was too long. In that view of the matter, this court, therefore, taking into account that the court below, both the courts below have decided the question of limitation on the basis of the service being not affected, the service being affected. And on that premise have decided the Section 5 application. The entire exercise for discretion, for deciding the, for exercising the discretionary jurisdiction have been rendered faulty. Now, coming to the facts of the instant case, it would be seen that the petitioner herein on 3/2/2020 had filed the, why it is 120 days? How is it 120 days? 30 days will be 510. January, 31 days, plus 5 days, 4 days, 35 days. Then here, 31 days. 34, 35, 35 plus 31, how much? Plus 30,
66,
plus 30,
96.
and 31.
One 170.
Eh?
172.
17.
Yeah.
And then you have to minus 512, 512. I think it will be less than 110 days.
Yes.
Effective. Because you have to minus 30 days, no?
73 days.
Hmm?
It will be 73 days.
No. You have to take another days, no? You came to know on 5/9/2019,
Yes.
which means another 25 days here. 25 days and 5 days here it will go. So it will be 112 days effect. Okay, let me come back and pass the remaining portion. I don't know, 21, which year?
This is it is 2017, 19.
The 4 week.
Problem.
The request, you are appellant?
No, I've taken the
The request of Mr. Nobody.
Supplementary list for judgment. Item number 20 to 41.
Take it. Repetition stands dismissed.
Item number 15.
Now coming to the facts involved in the case. It will be seen that the delay in filing the state application under Order 9 Rule 13 would be 120 days as stated by the petition. Taking into account from the date of knowledge of the judge of the judgment and decree passed in that date of decree, the date 14/12/2018. The above facts would also show that the facts also show that the petitioner hearing had submitted a medical document as regards the ailment. It will also be seen that the petitioner is a retired employee. The retired employee,
Now he retired.
as on the date of filing, also he was a retired, was shown as
60 years, yes,
61 years. The retired employee. And further to that, the suit having been filed against the petition, showing the petitioner's address, indicating an address which was not the address mentioned in the registered deed of agreement for sale dated so. This court is of the opinion that the consideration for condonation of the delay has to be liberally construed. Under such circumstances, this court therefore condones the delay. Thereby allowing the application under Section 5 so filed by the petitioner. Further to that, as already observed here in above, taking into account that the order by which, taking into account the order dated 28/8/2018, whereby the court had deemed service being effected upon the petitioner on the basis of an advertisement contained in the newspaper Ohomia Protein, published on 5/8/2018, to be not in accordance with the provisions of Order 5/2020. This court further allows the application under Order 9 Rule 13, thereby setting aside the judgment and decree dated 14/12/2018, passed in that suit number the revision petition therefore stands allowed. This court grants the petition 30 days time from today to submit the written statement before the court below. And the court below, before the court of the Munsif, before the court of the Munsif at not Lakhimpur,
Not
Lakhimpur, within a period of 30 days from today. And thereupon the state trial court, the learned trial court shall proceed and adjudicate the state dispute as expeditiously as possible in accordance with the above.
So for paint is concerned, I think address part will have to be amended. Obliged.
In fact, what the mistake they did,
Yes, for a small mistake from the
no.
part of the council.
They initially thought, right, the address will go there. This person should have received. He had the power of attorney.
Yeah.
He should have accepted. But maybe that didn't click in their mind. And therefore they took.
Unfortunate client. That's all. Obliged.
I know 42.
Yes, did you get the judgment?
Oh, my lord, I got this latest judgment, but then not the one, my lord, which says that rectification can be done in the schedule, my lord, at any point of
You
time.
didn't get it.
I have got the that new judgment by Life Insurance Corporation as Justice Partywala judge.
Those are different.
But-
Mr. P.T. Goswami, the learned counsel appearing on behalf of the petitioner. You have taken service upon notice to respond before the none appears on behalf of the respondent from court. It appears from the order dated 1/6/2023 passed by the Lozima Court. That the service of notice upon the respondent have been duly effected. Considering the above, the instant petition is taken up for disposal. The instant application has been filed under Article 227 of the Constitution, challenging the order dated 11/7/2013 passed in title suit number 48/0809, whereby the application seeking amendment of the claim was rejected on the ground that the same was filed at the stage of arguments. The application seeking amendment of the claim have been enclosed as Annexure 3 to the application, to the revision application. A perusal of the said amendments sought for is in relation to certain amendments sought to the schedule, to the plain, and more particularly relating to the description of the land. At this stage, this court finds it relevant to refer to Order 7, Rule 3 of the Code of Civil Procedure 1908, which stipulates that where the subject matter of the suit is an immovable property, the plain shall contain a description of the property sufficient to identify it, and in such case, property can be identified by boundaries or numbers in a record of settlement or survey, and the plain should specify such boundaries or numbers. It further reveals from Order 20, Rule 5, not that, Order 20, Order 20, Rule 9, that when the subject matter of the suit is an immovable property, the decree shall contain a description of such property as sufficient to identify the same. And when such property can be identified by boundaries or by numbers in the record of settlement or survey, the decree shall specify such boundaries or numbers. The Supreme Court, in the case of Pratibha Singh and another versus Santi Devi Prasad and another reported in 2003 to GSCC 330. Observe that paragraph number 15 that if the plaintiff committed an error, the defendant should have objected to it promptly. It was observed that the default or carelessness of the parties does not absolve the trial court of its obligation, which should have, while scrutinizing the plaint, pointed out the omission on the part of the plaintiff and should have insisted on a map of an immovable property forming the subject matter of the suit being filed. The Supreme Court further observed in paragraph number 17 that when the suit as to an immovable property has been decreed and the property is not definitely identified, the defect in the court's record caused by overlooking the provisions contained in Order 7 Rule 3 and Order 20 Rule 3 CPC is capable of being cured. On the basis that after all, a successful plaintiff should not be deprived of the fruits of the decree. It was observed that a resort can be had to Section 152 or Section 47, depending on the facts and circumstances of which case, which of the two provisions would be appropriate. Just and convenient to invoke. It is also no longer res intriga that the amendment of the schedule to the plaint on the above rationale can be permitted at any stage considering the above, this court, therefore, upon perusal of the amendment application and the amendment sought for is only limited to the description of the scheduled land.
There is one, my lord, 2 in the schedule and 3, my lord, the third amendment, that is the figure typed as 11 and 1/4 in line 20 of page 5 of the thing, would be corrected as 6.
That is the description of the land.
Description, my lord, this is to describe the share in the each of the brothers, the 4 brothers, one is a 20-year defendant. But
The description of the scheduled land.
This doesn't figure in the this is only in that particular
Description relates to the description of the scheduled land and the share and the claim of the share. This court is of the opinion that this is a fit case for exercise of jurisdiction under the supervisory jurisdiction under Article 2 to 7 of the Constitution. For setting aside the impugned order dated 11/7/2013 and thereby allowing the amendment as sought for by the application dated
Amendment application dated
28
28
5/2013,
Yes.
being petition number 1550/2013. In that view of the matter, the amendment applications is allowed. Amendment application being petition number 1550/2013 is allowed. And the petitioner, who is the plaintiff in the suit, is directed to file the amended plaint within a period of 14 days from the date of the instant order, failing which the provisions of Order 6, Rule 18 shall duly apply.
May I just say 3 weeks, 20 days, Nagaon.
7 days? 7 days.
No, man, 7 more days.
No, no,
Your lordship is-
not, these are 2013 matters. I can give you 7 days if you want 7 days.
14.
Record is finished. The registry is directed to forthwith. And the trial court shall thereupon upon filing of the instant application shall proceed with the suit by giving due notice to the defendants who have, however, not appeared before this court.
In spite of service. In spite of service. They have not.
Not Nelly.
No, 17 for hearing.
Yes, Mr.
Well,
Davila.
matter was in fact art by a lot.
Which one?
Well, ultimately it was released because the bench got changed. Matter.
Oh, that matter. Then what happened?
Well, the judgment of repast. The original judgment is a place 30 matter.
Point is what? Whether the learned applicant has misplaced the burden of proof of the defendant regarding genuineness of Exhibit A, the sale deed. Whether the consideration of the evidence of the plaintiff is perverse and thereby vitiated by the judgment. Yes, what is Exhibit A? Exhibit 4?
Of tell it. There is 30 exhibit place number 4 matter. And in fact, well, the signature was.
You are the defendant.
something.
You have exhibited that document.
Yes.
Then
We have a 10 people color for the front get part. The judge of the court who was on the bed, my lord. But then report came, my lord, in my paper that the signature does not date. They challenge it, the trial court given another chance to can send it to somebody from other else. But they did not. Here, my lord, the land is, my lord, land I own 4 big and all, and it, of the LSLD, my
and
lord,
that has been set, that aspect has been, how did the first appellate court take into account?
well, first appellate court actually that given a pardon, my lord, last para, if you also see at page 58. Para 16,
Page 58,
para 16.
handwriting, handwritten.
My lord,
Page 58 is the handwritten one.
no, no. My lord, the appellate court judgment inside page 11.
this title suit. Page 68,
58.
58 to the trial court. Tell me which internal
Oh,
page,
internal page 11, my lord. Appellate judgment.
paragraph 16.
Yes.
Okay.
When the plaintiff has brought the suit for declaration of title and other relief, including recovery of possession in the garden lies, it prove the case. Plaintiff can succeed on the strength of their own leg. When evidence of record case the plaintiff has not been able to prove the exclusive title over the suit land, nor the plaintiff have been able to prove the alleged shall be forced. The accused judgment is decreed by land Calcutta Commission.
So you did not show any document to show your title.
Yes, we have shown, my lord. We say that, my lord, that the plan is joint plan. We dated from our father. To that extent, my lord, everything is done. If
No,
the lordship see the trial court judgment, my lord. Trial court judgment, my lord, your lordship may just
What was your source of title?
acting
Hmm?
son of the original.
File this suit praying inter alia for the scheduled call land, declare belong to all the heirs of so and
Yes.
past land, so and so, schedule when number 1 to contest to the filing as saleable right, saleable interest to the extent of the land shown in the sale be stated. Whether the land of scheduled call intent it mentioned in schedule O. How many sale deeds?
My lord, one tell it, different number 2, then different number 2, my lord, from that sold to different number 1. That is subsequent sale, but that is not to my lord. First thing, if it is sold it in paper, different number 2 is my lord bad, then everything goes bad.
So declare the two sale deeds of schedule C
Yes.
as fraudulent.
Hmm.
Schedule C is two sale deeds. Sale deed number 634/2004.
Yes.
This was
It was
what
subsequent, my
was
lord.
is the name
But
of the plaintiff?
Main sale is 219, 2139.
Name of the plaintiff is Methi Thakuria.
Yes.
Vendi Muslim Ali. Who is the vendor?
Venerable plaintiff number 4, original, that is Anil Thakuria. He is also brother, my lord. He died, my lord.
Oh, plaintiff number 4 is the vendor. And when did he die?
Died during pendency of the suit, my lord.
So he was alive when the suit was filed. So his case is that he never executed this
My
deed
lord.
of sale
My lord. And it
of
was,
2004.
while he was on bail, my lord, his signature was taken by the commission and it was sent to undertaking expert. You'll also find, my lord, that
Now tell me, how does the trial court take into account?
my lord, your lordship may see issue number 4, 5,
4 and
6.
5.
4, 5, 6.
Issue number 5 is there
Yes.
at page 33.
Yes, 33, my lord.
It
They
was
use exhibit for the only
Okay.
for so and so. Exhibit for reveal that plaintiff 7 in number have inherited the title, right title interest of for scheduled land jointly. There was no partition among the ownership of the plaintiff. The defense side failed to exhibit any document, adduce any evidence that the plaintiff owned that for scheduled land separately, and there was no partition. Defendant's witness Hamid Ali, he said he did not know that when Anil Thakuria was separated from his daughter. And own their secretary. He did not keep any written partition of Hamid and his brother. Defendant Mali said that he did not know the partition of Anil Thakuria among his brother. Thus, I hold that all and plaintiff and their assistants. And four is, as per discussion is number 1 and 5, Exhibit 4. I put it in that Exhibit 4 land was a joint Ajmali land. The plaintiff inherited from Assaram. There is no partition among the owners. I find all that
Issue number 4 has been wrongly decided by the trial court also. Wouldn't section 44
Yeah.
of the transfer of property apply?
my lord, but to the extent, my lord,
Yes,
Correct.
to the extent. How much was sold? The
To
entire
extent-
land?
Yeah,
Entire land was
entire
sold.
land, well, roughly 4 katha and what? 4 bigha and what? So it says, my lord, there's no sellable interest tax and
Let's see issue number 6. How does the
Now, my lord, the fee also, your lordship may see, my lord, that regarding the what you have to
definitive,
sell.
executed signature Q1 to Q have not been written by the written table. So they filed objection against that report.
Yes. Then they were allowed to send it to some other object.
They did
take
not.
it. They did not take it.
Did they cross-examine, ask the cross-examination of the,
They did not report it.
that is,
And moreover, appellate court will neither said that the appeal on issue wise nor send any issue on the issue which mallory is said.
you want an order of remand?
No, not that, but just I am submitting, my lord, that that has not been done, my lord.
You want an order of remand, this court will be happy.
Because
Let us see how whether such sale deed was executed by the defendant number 2 in favor of defendant 1. That is not necessary.
they are 10 onwards, my lord.
And regards the sale deed in respect of 4 acres of land of the allegedly executed by the in favor of the plaintiff as stated in the pleading that defendant did not execute the deed to mention as
There are 10.
Oh, paragraph 13.
The export of the expert, so you need to obtain expert, not a substance, so it cannot take it. Expert means on business. Food, connect upon durable business. So that's what expert, order, let upon, got support, like any other business. Every order, take up, like the people. Because of this, and help you to like part of it. Certainly, therefore, you know that, this like part, I mean, other part, but then there's but the other part, then there's that the
No, what is your prayer? You have asked for challenging the, didn't you challenge the deed of sale?
yes, it's a Portland.
Pass the decree declaring the right title on the plaintiff is not affected by the sale deed rate to be cancelled. So that prayer is there.
That's a Portland matter. With plaintiff number 4, the party. And
Was there any denial by the defendant that the plaintiff originally did not have the title? Couldn't have. Because of the fact that the defendant was claiming on the right which devolved upon them on the basis of the deed of sale. Yes, Mr.
If your lordship go through the paragraph 14, my lord, it is the vital part of the judgment. And if evidences are produced, my lord, then everything will be clear.
What is that?
At internal page 8 of the appellate court judgment,
What does it say?
page 55.
Yes.
No doubt the plaintiffs in their pleadings have denied the execution of sale deed number 21393, exhibit 4, allegedly executed by defendant number 4 in favor of the defendant number 2. But plaintiff number 3, while examining him as PW1, admitted in unambiguous terms that the defendant number 4, Anil Thakuria, by executing registered sale deed number 21393, transferred the land measuring 4 biga 1 lesser in favor of the defendant number 2. The plaintiff number 3 also stated in his evidence that he has not filed the suit for cancellation of the sale deed executed in favor of the defendant number 2. So he has not challenged the sale deed. Exhibit
But
4.
Mr. Chaudhary, are we not going to look into the plain whether he has done or not?
But he himself, in evidence, my lord,
Evidence that he may not. How the evidence is being taken is a different aspect of the matter. He may not. He may have stated out there that the defendant, the plain defendant number
another
4.
part, my lord,
Yeah.
the sale deed was executed by the plaintiff number 4. He was alive at the time of filing of the suit, and for
his illness, the reason shown that for his illness he could not come to the court. So a commission was appointed for taking signature and thumb impression. But no commission was appointed, no commission was sought for examination of the plaintiff number 4. No evidence was laid by him.
He died before the report came.
But he was alive during
Understood, but before the
during-
report came, he died.
during the time of examination of witnesses of the plaintiff. He was alive.
Understood,
The
but he
plaintiff
died at that point of time
after
when the report came.
report when report came, he died.
Then
But before that, he was alive. When they were examining plaintiff's witnesses, he was alive. Then he could have adduced evidence regarding this, and his document that has been challenged here as fraudulent. The standard of proof as regard fraud, that should be beyond reasonable doubt, my lord. That aspect of the method
the
that has been
report
discussed.
categorically shows that these are not his signatures.
But,
Why haven't you challenged the
but,
report?
But that report, my lord, the hypothetical report, my lord, this is
You
an,
can't say that
this-
now.
This is an opinion, my lord. This is an opinion,
No, that's evidence.
and that opinion, my lord, this should be corroborated by the other evidence. So if your lordship
They are
goes-
already saying out there that this person did not sign it.
my lord,
Now, therefore, the signature was sent.
if my lord, they have
Why haven't you challenged that report then? You should have,
Object-
you have
object-
only filed an objection.
Object-
You were giving an
objection-
opportunity.
Objection was filed, but the expert was not examined, my lord.
Is it required? Is it required? See orders 26 rule 10.
Uh,
Is it required?
my
The
lord,
trial court is absolutely, the first appellate court is absolutely wrong, did not understand what is order 26 rule 10.
Rule 10, my lord, that opinion has become part of record, my lord.
No, it's a part of the, it becomes a part of the evidence.
Part of the evidence of that.
It becomes evidence.
is
So the
another
moment
aspect
it becomes evidence,
that
you want to, you have objection, you have to ask for
that is other aspect of the
cross-examination.
matter. But
Why didn't you ask for
only
cross-examination?
on the basis of the opinion, how a suit can be dealt with, my lord? That is the question.
Why not?
Only on the basis of the
They have
opinion,
been
the
all
trial
along
court
there.
has
The plaintiffs have all along been denying to the fact that the sale deed was never executed by him. The defendant number 4 also had stated, but his evidence was not recorded at the time.
But the other witnesses, my lord, who challenged the document, my lord, main document, sale it, their evidences may be kindly seen, my lord. What they have said in
Hey,
the cross-examination, my lord.
I'll see.
The cross-examination part of the PW1, my lord, Nogen Talukdar.
I'll see. Evidence ni ko. Let us see.
PW1, my lord, Nogen Talukdar.
PW1, let us. What is his name? Nogen
Sri Nogen
Talukdar.
Talukdar.
Huh?
Nogen Talukdar.
Yeah.
Plaintiff is known to me. The names of the plaintiff's brother are late Prasanna Thakuria, Bhavan Thakuria, Onil Thakuria, and another Tarini Thakuria. The plaintiff resides at
Who is the PW1?
PW1
মই এই গোচৰ বাবদি বিবাদিক চিনি পাওঁ, meaning that he is not the plaintiff.
is plaintiff, my lord.
He can't be because he says মই এই বাদীৰ গোচৰ বাদী আৰু বিবাদিক চিনি পাওঁ।
Next, my lord.
মই এই গোচৰৰ বিবাদিক চিনি পাওঁ।
PW3, my lord. Medi Thakuria. Medi Thakuria evidence.
মই গোচৰৰ এজন বাদী। This one.
Medi Thakuria. We are 5 brothers. Bhavan Talukdar, Onil Thakuria.
Let us also read what you call his chief.
Medi Thakuria is plaintiff. We are 5 brothers. Bhavan Talukdar, Onil Thakuria, Torun Thakuria, Prasanna Talukdar are my brothers. The said Prasanna Talukdar died, but others are living. The Pradip, Girish, and Prakash are the sons of
Prasanna Thakuria is?
Prasanna Thakuria is also brother.
Is the plaintiff number 4?
Plaintiff number 4, Onil Thakuria.
Okay. Bhavan Talukdar, Bhavan Talukdar, Onil
Talukdar,
Thakuria, and
Onil Thakuria, Torun Thakuria, Prasanna Talukdar are my brothers.
Prasanna Talukdar died, but others are living. Pradip, Girish, and Phukon. Phukon, who is the
Pradip, Girish, and Phukon are the sons of late Prasanna Talukdar. If one brother died, their sons are these men. I and my brother Prasanna lived at Dangardi village. My brothers Torun and Bhavan live at Tarmatha village. Onil lives at Bordhantali village for the last 15 years. This suitland comprises about 5 bighas of land. Pata number 7 consists about 5 bigha of land having 2 numbers of dag. I do not remember the relevant dag number. I have filed the suit claiming the said 5 bigha of land. I do not know if there is other land also in the relevant pata of the suitland. I know defend number 2. I do not know any proceeding under section 145 CRPC between Onil Thakuria and defend number 2. I do not know if possession was declared in favor of the defend number 2 under section 145 CRPC proceeding. I do not know if any sale deed was executed in favor of the defend number 2.
I do not know if any sale deed was executed in favor of the defend number 2 in
respect of the suitland.
However, I came to learn that the scheduled land was sold to the defendant number 2 by the defendant in respect to the suitland on execution of the deed of sale.
Yes. It is a fact that on 992
granted in favor of him in respect to
mutation was granted in favor of the defend number 1 and 2 in respect of the suitland. I have submitted an application before the concerned circle officer for cancellation of their mutation. However, I have not submitted any copy before this court in this present suit. The concerned Latmandal and SDC are not be made the witness in this suit. I have claimed in this suit about 2 bigha 1 lesas of land. I have not filed this suit against the land purchased by defend number 2. He has not filed this suit against the defend number 2. Defend number 2 is the original purchaser. I have not filed this suit for cancellation of sale deed executed in favor of defend number 2. The original sale deed that has not been, he has not challenged according to his evidence. It is a fact
that registered deed number 21393 Onil Thakuria transferred the land regarding 4 biga 1 lesser in favor of the defendant number 2. So everything has been admitted, my lord, here in his evidence. It is a fact that I have described the registered deed in the schedule for schedule go, and is that schedule no description of land in is mentioned. It is a fact that the schedule go, I have not mentioned the details, particulars of the land in question. Two bigger land, tag number 53, patta number 7 was sold to defend number 2. The land is bounded by as follows. On north, Nogen Talukdar, Dibbo Busho, Nogen in the south, on east, Nogen Talukdar, on west, Dibbo Busho. The boundary of the land 5 biga is same as stated above. In KP Patta number 233 and Dag number 50, arising from 1 biga 3 kotha 5 lesser was 3 kotha 1 biga
Mr.
3 kotha
Chaudhary,
5
let us
lesser
read the
purchased
chief
by the
of
Onil
that
Thakur.
person,
My lord,
chief of PWP
chief of Medi Thakuria.
of that person, na PWP. Medi Thakur. Here,
মই গোচৰৰ এজন বাদী, বাকী বাদীগণ মোৰ ভাই আৰু ভতিজা। এই গোচৰত বাদীগণৰ একে স্বাৰ্থ। বাদী আৰু তেওঁৰ ভাইগণৰ মাজত সম্পত্তি বিভাগ হোৱা নাই যদিও কোনোৱে নিজৰ সুবিধাৰ্থে বেলেগ ঠাইত বাস কৰি আছে। ডাঙৰদি গাঁৱৰ গোচৰীয় জমি বাদী আৰু ভাইগণৰ উমৈহতীয়া জমি। বৰ্তমান 1 নম্বৰ বাদীয়ে এই সকলোৰে পৰিচালনা কৰি থাকে। যোৱা 25/11/2004 তাৰিখ ইংৰাজী তাৰিখে বিবাদীয়ে হঠাৎ দেখিব পালে যে 1 নম্বৰ বিবাদীয়ে কেইজনমান লোক যি আৰ্জিৰ তফচিলৰ জমিত প্ৰৱেশ কৰি তাত খেতি বাতি কৰাৰ যোজা কৰিছে। বাদীয়ে বাধা প্ৰদান কৰাৰ উক্ত জমি 4 নম্বৰ বাদীয়ে 2 নম্বৰ বাদীৰ বৰাবৰে বিক্ৰী কৰি দিয়া বুলি জনায় আৰু 2 নম্বৰ বিবাদীৰ পৰা 1 নম্বৰ বিবাদীয়ে খৰিদ কৰি লোৱা বুলি জনায়। 1 নম্বৰ বাদীৰ বাধা নুশুনি সিদিনাই 1 নম্বৰ বিবাদীয়ে জমি দখল কৰে। 1 নম্বৰ বাদীয়ে 4 নং বাদীক যোগাযোগ কৰি সোধাত 4 নং বাদীয়ে কেতিয়াও কোনো জমি বিক্ৰী দলিল কৰি দখল সমজাই দিয়া নাই বুলি জনায়। ইয়াত প্ৰকাশ থাকে যে 4 নং বাদী বৰ্তমান অতি গুৰুতৰভাৱে অসুস্থ হৈ আৰু কথা ক'ব নোৱাৰা অৱস্থাত প্ৰাপ্ত হৈছে। গতিকে 4 নং বাদী কোনো প্ৰকাৰে কথা ক'ব পৰা অৱস্থাত নাই। 1 নম্বৰ বাদীয়ে বেলচৰ চাব ৰেজিষ্টাৰ তফচিলৰ খবৰ কৰি আৰ্জিৰ তফচিলত বৰ্ণনা কৰা 683 নম্বৰ 2004 চনৰ দলিলৰ বিষয়ে জানিব পাৰে আৰু তাৰ স্বাক্ষৰিত নকল লয়। দলিলত চৌহদ ভুল দিছে যদিও আৰ্জিৰ তফচিলত বৰ্ণনা কৰা জমিয়ে উক্ত জমিৰ বৰ্তমান 1 নম্বৰ বিবাদীয়ে দখল কৰিছে। 683 দলিলৰ বিক্ৰেতা হিচাপে 2 নম্বৰ বিবাদীৰ নাম দেখি বাকী বিবুদ্ধিত পৰে। তাৰ পিছত পুনৰ বহুতো বিচাৰ খোচাৰ কৰি নলবাৰী চাব ৰেজিষ্টাৰ অফিচত 293 দলিলখনৰ বিষয়ে জানিব পাৰি 6/12/2004 ইংৰাজী তাৰিখত স্বাক্ষৰিত নকল লয়। বাদীয়ে উক্ত 2013-93 নম্বৰ দলিলৰ বিষয়ে স্বাক্ষৰিত জনা নাছিল। আনকি উক্ত দলিল মূলে 9/9/2004 ইংৰাজী তাৰিখলৈ নামজাৰি হোৱা নাছিল। 9/9/4 ইংৰাজী তাৰিখে নামজাৰি পাছ কৰে বাদীগণৰ অজ্ঞাতে। 1 নম্বৰ বিবাদীয়ে তফচিলৰ মাটি বেদখল নকৰা পৰ্যন্ত বাদীগণে জমাবন্দী নকলো লোৱা নাছিল। 9/9/2004 ইংৰাজী তাৰিখৰ নামজাৰিৰ বিৰুদ্ধেও জনা নাছিল। আনকি 25/11/2004 তাৰিখৰ আগতে গছৰীয়া জমি 1 বা 2 নম্বৰ বিবাদে দখল কৰা নাছিল। আৰ্জিৰ গ তফচিলত বৰ্ণনা কৰা দুয়োখন দলিল চক্ৰান্তমূলক আৰু জাল। এই দলিলৰ দ্বাৰা ক তফচিলত বৰ্ণনা কৰা জমি বাদীগণৰ স্বত্ব স্বামিত্বৰ কোনো হানি হ'ব নোৱাৰে। এই দলিল 4 নম্বৰ বাদীয়ে কৰি দিয়া নাই আৰু উমৈহতীয়া জমি হোৱা হেতুকে দলিল কৰি দিয়াৰ এখতিয়াৰ নাই। He said reverse in his evidence. So where is the how he has established the fact stated in the pleadings regarding challenge of the sale deed that it was fraudulently executed. Since he admitted the entire sale deed, how he can say now that the sale deed has been executed fraudulently? In his own evidence, he has stated he knows about the execution of the sale deed by the plaintiff number 4.
Let us read further. Let us read further. বাদী আৰ্জিত বৰ্ণনা
আৰ্জিৰ গ তফচিলত বৰ্ণনা কৰা দুয়োখন দলিল চক্ৰান্তমূলক আৰু ভাল। এই দলিলৰ দ্বাৰা ক তফচিলত বৰ্ণনা কৰা জমিত বাদীগণৰ স্বত্ব স্বামিত্বৰ কোনো হানি হ'ব নোৱাৰি। এই দলিল 4 নম্বৰ বাদীয়ে কৰি দিয়া নাই আৰু উমৈহতীয়া জমি হোৱা হেতুকে দলিল কৰি দিয়াৰ এখতিয়াৰো নাই। দুয়োখন দলিলতে চৌহদ ভুল বাদীয়ে ক খ তফচিলত শুদ্ধ চৌহদ দিছে। বাদীৰ আৰ্জিত বৰ্ণনা কৰা সকলো কথা এই শপত পত্ৰৰ অংশৰূপে বিবেচিত হ'ব আৰু সেই সকলো উক্তি সম্পূৰ্ণ সত্য বুলি এই শপত পত্ৰৰ দ্বাৰা ঘোষণা কৰিলোঁ। প্ৰতিদ্বন্দ্বিতা কৰা বিবাদীগণৰ বৰ্ণনাৰ উক্তি মিছা ও ষড়যন্ত্ৰমূলক। এই গোচৰ দায়েৰ কৰাৰ সময়ত 4 নম্বৰ বাদী সাধাৰণ অসুস্থ আছিল। বৰ্তমানে তেওঁ শয্যাগত আৰু লৰাচৰা কৰা
কৰিব নোৱাৰে।
বতৰা একেবাৰে কৰিব নোৱাৰে। 4 নং বাদীয়ে আদালতৰ আগত সাক্ষী দিয়াৰ বাবে উৎসুক আছিল যদিও বৰ্তমান সম্ভৱ নহয়। প্ৰদৰ্শক 1 পকোৱা মৌজাৰ ডাঙৰদি গাঁৱৰ খেৰাজমেদি 7 নম্বৰ পাতাৰ জমাবন্দীৰ স্বাক্ষৰিত নকল। প্ৰদৰ্শক 2 এই মৌজাৰ এই গাঁৱৰ খেৰাজমেদিৰ 33 নং পাতাৰ জমাবন্দীৰ স্বাক্ষৰিত নকল। প্ৰদৰ্শক 3 খাজনা ভৰাৰ ৰচিদ।
Let us see your evidence what you have stated. And the PW4
Yes.
50 ইমান 51 number ডাগৰ মাটিত ইমান আছে। PW4 is also the one of the plaintiff.
Yes, ma'am. Hogan Talukdar. His evidence also maybe.
জাল দলিল কৰি থাকে।
His evidence is also important. Maybe also. May I read his evidence also?
I read it.
Hogan Talukdar.
I did not inquire from Anil about the execution of the sale deed in Kuch.
He admitted, my lord. He also admitted. He says, I do not know if Onil sold some land to the defendant number 2 by executing sale deed. I do not know what extent the defendant number 2 sold the land to defendant number 1. He knows nothing. I do not know the tag number, pata number of the land sold by defendant number 2 to defendant number 1. The land sold by defendant number 2 to defendant number 1 is as follows: North Nogan Depot, South Depot, East Depot, and West Nogan. I have not mentioned the boundary in my affidavit. I have not filed any application for cancellation of mutation after execution of the sale deed number 683 and 21393. We have filed the suit for declaration of title sale deed to be illegal. It is not a fact that the land belonged to O'Neill, who sold the same to defendant number 2 in the year 1993. I did not inquire from O'Neill about the execution of the sale deed in question. I do not know about the proceeding under section 145 CRPC between O'Neill and Tomis.
Okay. Yes, Mr. Sahola. Show me any part of the evidence that you have stated that Anil Thakuria did not sign the document, that the signature or the thumb impressions are not his.
No, we have stated or challenged it, my lord, that is the lordship will see the exit number, my lord. Again,
Because PW3 and PW4 were the plaintiff.
Yes.
PW4 in his cross-examination state that I have not inquired with Anil as to whether he has executed the document. PW3 states do not say that these are not his signature. Because he may know, even his brother may know. These are. Now, can the handwriting expert opinion solely, yes, it is evident, without any further corroboration, be considered to be an evidence for the purpose of citing the legality of the particular thing?
Well, the other aspect is here. The deed was executed elsewhere. First, deed was executed elsewhere. That's how it was elsewhere. Whereas the land is in Nalbari. Second deed was executed somewhere.
So you say that he didn't have the registration, but
Yes, that is not proper. That's coming at that.
but is it stated out there in your plain?
In not the plain evidence. So that
If it is not there on the basis of your evidence, of the plaintiff, of your plain,
just
then
minute.
can it be taken as a ground?
I'm just
Can it be a substantial question?
but Shelby itself also developed that it should be
Understood, but to become a substantial question of law, it has to have the foundation of the, in the plain.
because the main thing that whether the study did or not, that is that they have to prove it.
Why do they have to prove it?
Hello?
You are alleging that the document is fraud.
Yes.
So isn't it your duty to show it? Yes, you have shown it by there is a particular piece of evidence and right, but wouldn't it require corroboration?
The court can also compare it.
Understood. Court can very well compare under 73, but there's already an evidence.
Yes.
It becomes a piece of evidence because of Order 26 rule
Well,
10.
yes.
Becomes. But isn't required to be corroborated?
Well, that is it will be
The moment you discharge that onus, then the onus shifts upon him.
just time.
Because from his evidence, he have not been able to prove that the document was signed, document was executed.
Well,
But when you are saying
I have said,
alleging
my lord,
fraud, huh?
it will be said in the দুইখন দলিল চক্ৰান্তমূলক আৰু জাল আজি ঘটনা দুখন দলিল চক্ৰান্তমূলক জাল এই দলিল দ্বাৰা ক তফচিল বৰ্ণনাৰ জমি কোনো আজি হ'ব নোৱাৰে এই দলিল চাইনৰ বিবাদীয়ে কৰি দিয়া নাই আৰু উমৈহতীয়া জমি বা দখল দিয়া নাই in fact my lord defendant number 2 admitted that he has not possessed the land
That I could see from his evidence.
দুইখন দলিল চৌহদ ভুল বাদীয়ে আৰু তফচিল শুদ্ধ চৌহদ দিয়ে
You are reading whose evidence?
my lord P2C para 7 in a chief
এরা
7 at page 6 আৰ্টিৰ
আৰ্টি
ক
ক
তথ্যত বৰ্ণনা
তথ্যত
কৰা দুইখন দলিল চক্ৰান্ত ব্লক আৰু জাল এই দলিল দ্বাৰা ক তফসিল জমি বৰ্ণনা কৰা জমি পাতিকণৰ শান্তি পাব নোৱাৰে এই দলিল 4 নম্বৰ পাতিয়ে কৰি দিয়া নাই আৰু উমৈহতীয়া জমি হোৱা দখল কৰি দিয়াৰ একো নাই দুইখন দলিলতে চৌহদ ফুল আৰু বাতিয়ে শুদ্ধ চৌহদ
then how do you explain his cross?
Cross mallet, in fact, mallet, sometimes mallet, it happens. The Tyson is given mallet, that is not a mallet, it's not a correct mallet. That appears mallet. Otherwise, it cannot be mallet. Because the same statement is there in Schedule 4 also mallet, that is not a fact. It is not a fact that is mallet. It is Tyson mallet. Otherwise, in 1993, one person purchased the land and he will not possess it, my lord. And that too, salary is executed from other subjects. You the code, my lord, not that the code is respect factor.
Anything else?
My lord, that
You want to show some judgment?
yes, but only one judgment, my lord. I am placing one para, your lordship.
My lord,
That
what has been submitted, my lord, that these are suggestions. So it is not that much clearly stated in his evidence. My lord. I have not filed the suit against the land purchased by the defendant number 2. I have not filed this
So
suit for
Chaudhary, you
cancellation
have
of
to
the sale
also
deed.
take note of
These are
this is a person who has signed out there with his thumb impression. You have to take note of that also.
Para 13 months. Yeah.
but I am citing some judgment melody.
You know?
13, 150, my lord. At page 590. My lord.
Yes.
But last page melody, last paragraph. PV conflict. There are other difficulties in the plaintiff's way which have been sufficiently considered in the judgment of the High Court. Fraud of this nature, like any other charge of a criminal offence, whether made in civil or criminal proceeding, must be established beyond reasonable doubt. The High Court was justified in holding that the trial judge's finding was largely based on suspicion and conjecture. So here, in this case, also from the very beginning, melody in the plaint, they have stated that they are these are co-owned property. This is co-owned property, and they do not have partition, etc. But no whisper has
But
been
Mr.
made.
Chaudhary, we are only on the question whether if the sale deed 213 goes,
Yes.
whether co-on or no con doesn't have
There-
any relevance.
That in respect of it, Malad, I have cited this judgment. This should be Malad beyond all reasonable doubt, Malad. It should be proved, Malad. And so far fraud is concerned, Malad, I cite another judgment of the Supreme Court, 76-1 SCC is 747.
What does it say?
Malad.
Relating to?
Same Malad. Same issue, Malad. On the basis of the PV Council judgment, Malad, this case has been decided by the apex court. Same view has been taken.
Anything else? Heard Mr. G.N. Sahiwala, the learned senior counsel, assisted by Mr. Tuti. The D. Chaudhary appears on behalf of the respondent numbers 1 and 2.
Yes.
The instant appeal was admitted by the court by framing the following by the appeal was admitted by this court on 9/5/2013 on the following substantial questions of law. Huh? The learned counsel appearing on behalf of the respondent submits that the said substantial questions of law so formulated by this court under section 100(4) of the Code of Civil Procedure 1908, or short the code, do not arise for consideration in the facts involved in the instant case. In that view of the matter, this court finds it relevant to take note of the brief facts of the instant case. The appellants herein as plaintiff had filed a suit being title suit number 38/2004 against the respondent numbers 1 and 2. Against various defendants, against the respondents herein who were arrayed as defendants. The case of the plaintiffs, for the convenience of this court, the parties herein are referred to in the same status as they stood before the trial court. The case of the plaintiff is that they were the joint owners of a suit land as have been described in Schedule Q. To the plaintiff. It was mentioned that there was no partition amongst the plaintiffs. And the plaintiff number 1 had been managing and possessing the suit land on behalf of the other co-owners. On 25/11/2004, the defendant number 1, accompanied with other persons, trespassed into a portion of the Schedule Q land, which have been more specifically described in Schedule Q. When the plaintiff number 1 raised objection, the defendant number 1 disclosed that the plaintiff number 4 sold the suit land as described in Schedule Q to the defendant number 2. And in turn, the defendant number 2 sold the same to the defendant number 1. The defendant number 1, it was alleged that the defendant number 1 forcefully occupied the suit land despite the protest of the plaintiff. The plaintiff number 1, upon inquiry, came to know that the plaintiff number 4 never executed any deed of sale in favor of the defendant number 2. And on inquiry in the office of the sub-register and the revenue authority, the plaintiff number 1 came to learn that the defendant number 1 and 2 got mutation over the suit land on the basis of a forged and fraudulent sale deed bearing number 213/1994. 1993. A perusal thereof showed that the plaintiff number 4 purportedly executed the deed of sale in favor of the defendant number 2. And later on, it was also learned that the defendant number 2 thereupon, by another deed of sale, transferred the land to the defendant number 1. It was the specific case of the plaintiffs in the suit that the plaintiff number 4 did not sell the suit land to the defendant number 2, and the sale deed executed by the defendant number 2 in favor of the defendant number 1 is also forged and collusive. On the basis thereof, the plaintiff filed a suit which was registered and numbered as title suit number 38/2004. Before the Court of the Civil Judge Senior Division, Nalbari, praying inter alia for a declaration of right, title, and interest over the land described in Schedule 4, for declaration of the sale deed number 213 and 683 to be illegal, which have been more specifically described in Schedule Go to the plain, for recovery of possession by evicting the defendants from the Schedule Core land, along with permanent injunction and a precept for cancellation of the mutation of the defendants. It appears on the record that the defendant number 1 and the defendant numbers 2, 4, and 5 submitted separate written statements. From a perusal of the said written statements, it transpires that the defendant number 2, by the deed of sale, from the perusal of the said written statement, it transpired that various preliminary objections were taken as regards the maintainability of the suit. It was denied that the lands of late Atmaram Thakuria belonged to the plaintiffs as Ismaili lands. It was stated that the defendant number 2 purchased the land from the plaintiff number 4 and had possessed the land openly, as the possession was handed over to the defendant number 2 by the plaintiff number 4. It was further mentioned that the defendant number 2, by duly acquiring the right, title, and interest, sold away a part of the Schedule Core land to the defendant number 1 on 7/7/2004. The sale deeds in question have been specifically described in Schedule Go to the plain. It was further mentioned that the mutation, that the said lands were also mutated in favor of the plaintiffs, on favor of the defendants. Since 1973. And as such, the filing of the suit was barred by limitation. On the basis of the various pleadings, as many as 9 issues were framed. The records of the trial court proceedings nine issues were framed, which are as hereindunder. 9 issues, over the net. Page 32. It appears from the records of the trial court proceeding that an application was filed prior to the framing of the issue application was filed. It further appears that on the basis of the issues framed, that on 16/12/2005, the suit was picked for cross-examination of the PW, on which date an application was filed, being petition number 615/617/05. Was picked for 16/12/2005 for cross-examination of PW. Prior thereto, on 6/6/2005, on the same day, an application was filed by the plaintiff for praying for issuance of commission for proving the signatures of the defense of the plaintiff number 4. And the case was fixed on 10/1/2006 for objection and objection hearing. It further appears that on 1/2/2006, as the defendant did not object to the said petition, the trial court. Duly taking into account that the plaintiff number 4 was in a bedridden and was in a bedridden and obvious and was in a bedridden and not in a position to come to the court. Appointed, issued a commission to the learned advocate Mr. Kaidar Ali of Nalbari Bar Association, directing him to collect and obtain the thumb impression as well as the signatures of the plaintiff number 4 in presence of the learned counsels of both the parties at any date before the next date, which would be convenient to the commissioner, and to submit the report. The record further shows that the commissioner submitted the report on 15/6/2006. And the case was fixed on 8/6/2006 for filing affidavit and objection on the commissioner's report. Number 2, produced the original sale deed number 213/1993. It further appears that the plaintiff had also filed an application to direct the defendant number 2 to produce the original deed of sale number 213/1993. The same petition, however, was withdrawn, and there was a direction by an order dated 15/7/2006 to the sub-register to produce the sale deed number 213/1993. While the same process was going on 5/1/2007, the plaintiff number 4 expired, and an application was trying to bring to substitute the legal heir of the plaintiff number 4. It further transpired that on 2/3/2007, the trial court directed the sale deed number 213/1993 to be sent to an expert along with the original plain copy, plain copy, and Wakalatnama to tally the signature of the plaintiff number 4. It further appears that on 2/4/2007, the defendant sought for review of the said order. However, by the order dated 13/4/2007, the said order was the said application seeking review was rejected. It further reveals that on 19/8/2008, one Deepak Kashyap had submitted the report of handwriting and fingerprint. Of 23/7/2008, the report of the handwriting expert and fingerprint expert was received by the court trial court. On 19/8/2008, the defendant submitted an objection It was observed that the defendant side did not file any objection against the commissioner's report as reflected in the order dated 15/5/2006. And as such, the trial court gave the liberty to the defendant to the effect that if the defendant side had any iota of objection in respect to the present handwriting and fingerprint expert, they may take fresh steps as per order dated 2/3/2007 to any other reputed expert of the choice of their choice and for fresh report. And accordingly, the trial court fixed the matter on 30/8/2008 for steps. It appears on record that the defendant did not take any steps as required under Order 23, Rules 10 of the court, or had submitted any other fresh report, the liberty of which was given by the order dated 19/8/2008. Be that as it may, the record reveals that the plaintiff adduced the evidence of 4 witnesses, and the defendant also adduced 4 witnesses and examined various documents. The trial court, by the judgment and decree dated 22/12/2008, decreed the suit in favor of the plaintiff thereby issuing a precept to the concerned sub-register to cancel the sale deeds described in Schedule God to the plaintiff, as they were declared null and void and inoperative in law, semicolon. Khas possession of Schedule Core land was to be delivered to the plaintiffs, semicolon. Mutation in favor of the defendant numbers 2 and 1 be cancelled and precepts be issued to the concerned authority, and permanent injunction was also issued against the defendants. Before further proceeding, this court finds it relevant to take note of that the trial court, while deciding the suit, and more particularly the issue number six, relying upon the opinion of the handwriting expert, held that the sale deed bearing number 213/93 held that the sale deed really clear too? Issue number 3 and issue number 6, whereby the trial court, basing on the report of the handwriting expert, held that the deed of sale bearing deed number 213/1993 was a fraudulent document and accordingly declared the same to be null and void, inoperative in law. In doing so, the learned trial court also held, therefore, that the suit was within the period of limitation. Being dissatisfied and aggrieved, the defendants herein as appellants, the defendant number 1 and 2 as appellants preferred an appeal before the first appellate court, that is the court of the district judge Nalbari. The said appeal was registered and numbered as title appeal number 6/2011. The first appellate court reversed the findings of the trial court and dismissed the suit on the ground that the plaintiff failed to prove their title over the land, as well as also failed to prove that the alleged deed of sale was forged. The basis of the said judgment was basis of the findings and observations of the first appellate court. Was primarily on the basis that the opinion of the expert is not a substantive piece of evidence, and it cannot be taken as a conclusive proof of the matter. It was observed by the first appellate court that an expert opinion is only an opinion evidence which the court can act upon a corroborative evidence. It was further observed that in a civil suit, in order to act upon a document, it is to be proved by examining the author. Inasmuch as acceptability and creditworthiness of an expert opinion certainly depends upon the probative value of such report. It was observed that the opinion of an expert cannot be relied on unless it is exhibited, and the expert is examined in proof of his opinion, and the other party is given opportunity to cross-examine the expert. However, in the instant case, the trial court not only, however, it was further observed by the First Appellate Court that in the instant case, not to speak of calling the expert to prove and exhibit his reports, and to give the other party an opportunity to cross-examine him, even the alleged report of the expert have not even been tendered in evidence or marked exhibit. It was therefore observed by the First Appellate Court that the status of the report of the handwriting expert was non-est, and as such, the court was not competent to rely upon an expert opinion, which was not even duly proved or brought on record. It is under such circumstances that the First Appellate Court, by the impugned judgment on order dated 14/2/2013, allowed the appeal and dismissed the suit. In the backdrop of the above, the instant appeal has been filed by the plaintiffs, challenging the impugned judgment and decree passed by the First Appellate Court dated 14/12/2013. And this court, as already noted here in above, had framed two substantial questions of law, had formulated two substantial questions of law. As quoted here in above. From a perusal of the two substantial questions of law, it transpires that the second substantial question of law transpires that both the substantial questions of law are interlinked and can be decided together in view of the fact that the trial court decreed the suit in favor of the plaintiff on the basis of the report submitted by the expert, and the first appellate court disregarded the expert report on the basis that the same was not exhibited, and the respondent and the defendants were not permitted, was not exhibited. In the manner required in the law. I've heard the learned counsels for the parties. Mr. G. N. Sahib, another learned senior counsel appearing on behalf of the appellant, submits that the report, handwriting report of the expert was a substantive piece of evidence which could not have been disregarded in view of the provisions of Order 26, Rule 10 of the Code. He referring to Section 45 and 47, read with Section 73 of the Indian Evidence Act 1872, for short, the Act of 1972, submitted. That it is not always necessary that a handwriting expert's report has to be relied upon, taken into account on the basis of corroborative evidence. He submits that it is for the decision to be taken by the court as to whether the handwriting expert is to be taken into account or not on the attending facts. In that regard, he relied upon a judgment of the Supreme Court in the case of Lalit Pokli versus Canara Bank and others, reported in 2003, 3 SCC 583, and more particularly to paragraph number 13. On the other hand, Mr. D. Chaudhary, the learned counsel appearing on behalf of the respondent number 1 and 2, submitted that the handwriting expert's opinion is a weak piece of evidence and has to be taken into account after taking into account the other evidence on record. He submitted from a perusal of the evidence cross-examination of PW3. It would be seen that he had duly admitted that the plaintiff number 4 had executed the deed of sale number 213/93 in favor of the defendant number 2. He further submitted that in the evidence of PW4, during his cross-examination, he further stated, he had categorically stated that he had not inquired with the plaintiff number 4, late Anil Thakuria, as to whether he had executed the deed of sale or not. Deed of sale bearing deed number 213/1993. or not. It is therefore the submission of the learned counsel for the respondent number 1 and 2 that merely on the basis of the handwriting expert's opinion and that too when the plaintiff number 4, plaintiff PW3 and PW4 who are the plaintiffs have categorically stated did not give any corroboration to the handwriting expert's report. The said reports could not have been taken as the sole basis for decreeing the suit, and as such, the First Appellate Court was right in dismissing the suit of the plaintiffs. The learned counsel for the respondent further referred to a judgment of the Privy Council in the case of ALN Narayanan Chettiar and another versus official assignee High Court Rangoon and another, reported in 2000 AIR 1941 PC 93 and submitted when there is an allegation of fraud. The said allegation has to be tested on the basis of there being proof beyond reasonable doubt. Unlike in a normal case, normal civil suit, which is decided on the basis of probability. He further submitted that 74? 74? Not necessary. Hello, less remaining, I will give it again. It's already 4:30. Get tired. I'll pass the order. I'll do one thing. I'll keep it on. I'll pass in your presence only because tomorrow I'll be sitting only till 11 o'clock. So not possible. Monday, Tuesday, whenever I sit, huh? I'm coming back after 2 days, but I don't know whether I'll be sitting in this bench or not. So we will take it up whenever I sit. Huh? You have an order to go to Bharat Mr. So. Hearing judgment people matters shown as part heard. Hearing completed, hearing almost complete, and as such matter be listed on 12/6/2023 and shown as part.